Without further ado, please join me in welcoming the convener of today's PAM Practice Talk, Chairman of the Professional Practice Committee, CPD Committee, Architect Hugh Chun Hao, to deliver his welcoming remark. Let's give him a warm welcome, please.
Good morning, everyone. First of all, very happy to see everyone in this hall, because I understand that today there is a multiple CPDs actually happening in PAM, including Sabah, Sarawak, and some also ask how's the audience or how's the attendance, which I understand that holiday also just started. So very happy that everyone still stay on for this topic. And of course, very thank you to the members, that also the guests, and also the speakers, including Daniel Tan, our very own legal advisor. So whenever we need to have any speakers on legal matters, I think it's quite easy for us to actually set up one paper. Thanks, Daniel. And also Mr. Chris Tan, welcome back again. I think Chris has been sharing a lot with us on Strata in the recent practice forum in December. And also we have Architect Sharina is still not in yet. I think it's a very good opportunity that we have Architect Sharina with us from Lembaga Architect to share a bit insight and data that I think we don't have it very often. And to Dongji Malaysia, Penten has been a great supporter to PAM, and also Smart Paint. I understand that it's actually their first event with us. Welcome. And all together, welcome to PAM Center. And I'm happy. Today's session is actually a collaboration between PPC and also CPD. So it's actually our first CPD, or we call it practice talk, in this year. In fact, this year we have actually planned for 2 events, which is the first request under CPD practice talk today, and also another one, our annual event PPF in December. So in case, I think some of you, maybe very often you may be very overwhelmed or think that there's a lot of CPDs, and how do we actually categorize it? So this term, I was actually tasked to also chair the CPD. So I happen to have a chance to just sit and talk a bit on actually how we organize the CPD. And this is what I actually gained. Basically, CPD, we have 3 main categories if you look through the calendars. So I think design lecture series, everyone is quite familiar with it. We have it on Wednesday of every month. It's more on the ideas, on speakers, design, that they have invited architects or any other speakers around the world. And the other one, we term it under practice talk series, which is what we are having today. And if you actually look into the poster, right, sometimes you see in collaboration. That means, right, these practice talks are actually related to certain committee. So it's an event that we actually had in collaboration with the committees. The subject matters that is exclusive for that committee. For instance, for today will be PPC on practice matter. So thirdly, number 3 will be, as you see here, will be the technical talk. So technical talk, you will normally see that there will be a collaboration with our industry partners, which will have a full session, 1 hour of more specialized talk. And we have also invited architects to talk on the similar subject. So I hope this will give a better understanding, because over the year, over the calendar year, I think we have, just for this year, we have about 60 CPDs that are going to happen. So in fact, actually, you have quite a lot of choices. So just pick the one that you like and then continue your support. Okay, next. I just want to talk a bit about the overview of PPC. Since this is the first event for PPC, I think it is important for us to, for me to actually just have a quick report on what we had in PPC for the last term. And I purposely played the video so that I don't need to repeat in detail. But as a whole, right, you can see that in last term, of course we changed already this term, we have PPC is actually under the 3rd cluster. So altogether, there's quite a lot of 17 standing committees across, and also we have a lot of task forces that are happening. So in nutshell, basically last term that I'm very happy to have been assisted or be supported by five very experienced chairmen, co-chair. And as you can see, standing on the five very strategic pillars, and this is actually how PPC actually perform. As you can see, there'll be standards, policy, advisory, clarity, environment. So all these are actually translated into the five working groups that we have in PPC. Then for quite some important numbers that are milestones that were achieved here, as you also can see in the video just now, we have under government level, we have actually attended more than 120 meetings, that including half of it is actually physical meetings and other workshops altogether. So of course the other one is also the firefighting red book. I think the red book that you are familiar, which we have published more than 500 copies, and the roadshow has been carried out across 6 cities with more than 600 participants. I think this is a good achievement overall. And this year, if some of you are aware, we have actually much reduced council members, so I think it also has to be very lean. And very lean and focused, and this is what we have here. So basically, we have restructured a bit on the practice PPC, and instead of a standalone committees, you will see a lot of the previous committees that actually been grouped under PPC as a working group. Example like the housing HUW and also the sustainability, which is a previous ESG. And okay, so how do we, before we start, how do we actually select the topic? These are a lot of issues that we deal with under PPC. So I think, so every day, everyone, these are the words, these are things that come to us. So how do we actually find a good topic or good subjects to actually share with the members? And of all these keywords that we see, I think we all actually face it almost every day. And these three words actually stand up that we thought is very relevant and thought is a good start for this term. And we are happy that we have three speakers, as I introduced just now, that is willing to come and share with us their topics. And if you look at these three topics, maybe we'll find that it's actually isolated, but offhand they are actually closely related. And altogether, all these topics basically leads to one very important term, which is the professional responsibility. That means if you start to understand what is a liability before and after, even in this case, we'll talk about afterlife, like what Daniel is going to share later. So from your understanding of liability, how do you perform your job in Strata? That means Strata is one of the form of projects that we have. And understanding it in mind, and how does this liability carry through when you are making any decision, any design or what in your Strata design, and eventually how this thing will affect your practice as, of course, from the perspective of lembaga, registration, even if you are deregistered, what happened after that. So altogether, we thought from these seminars, we are trying to connect these three, that as we can see from here, liability, strata, and practice, and by addressing the post-completion risk, strata, realities. That means Chris will share with us some common things that we also often face. In PPF, I think we have a high levels understanding on the strata, but in this case, we'll move a bit more into strata management and also the day-to-day operation issue at the properties itself. So end of the day, we just thought that this program will help the architects to actually achieve a better awareness, clarity, and also confidence. Okay, before I end, again, I just want to remind, and maybe you could just log your calendar, that our PPF 2026 this year has been set on 5th of December. And more details will be shared in due course, and we'll just hope we'll see you all for the registration. And so lastly, I think, again, I said today is a Saturday. Even though the topic sounds very hard, I think we can be a bit more chill and relaxed, and I hope you can enjoy the session, ask a lot of questions, and to take a lot of from our speakers here. Thank you very much.
Thank you, Architect Hugh, for the very thorough introduction of today's PAM talk and also PPC. Before we start with our first speaker, we will now have a presentation by Smart Paints, one of our event sponsors. Let us welcome Ms. Lim Wee Xian, Head of Specification, and she will be presenting on her topic. Let's give her she a warm round of applause.
Hello, everyone. My name is Wee Xian. I am representing Smart Paints Malaysia. Our goal is to provide localized, technically advanced palette of coding systems to match Malaysia specifications. So, in order to support market demand, coatings have undergone a technical evolution. We don't just look at paint as a product itself. It is a fully integrated system. And as you could see from our video clip earlier, Smart Paints manufacturing facilities are designed with automated production system. We offer architects absolute assurance on color tinting accuracy, and we are no longer using the old traditional ways. This is to eliminate batch-to-batch color inconsistencies, and with Smart Paints production capacity, we are able to meet your delivery timelines. We are able to ensure equal chemical formulation across high volume production. And over the years, Smart Paints has achieved a huge milestones. We have introduced first zero VOC paint in Malaysia. We have listed on ACE market of Bursa Malaysia, and we have also just launched Total Building System Solution last year. Our local innovation has allowed us to expand across Southeast Asia market, complying with each country design standards, with each country requirements. So all these developments reflect our commitment towards product quality, our commitments towards long-term industry growth. So today, we shall address a common industry headache in Malaysia tropical climate. Paint surfaces are constantly battling these issues, right? So even just right after project completion, the root causes include excessive moistures, insufficient coating curing time, incompatible systems, and sometimes workmanship issues. And dampness is very common, yet frustrating maintenance issue, or what we call as wall cancer. So if you have faced peeling paint, bubbles on walls, or moldy patches, you know how exactly very painful this problem. So in general, dampness comes from three main directions. Rising damp happens when ground moisture travels upward through the wall. And penetrating damp happens when external water, like long heavy rain, penetrates through your wall cracks or through the window sealant. And condensation is usually caused by internal room temperature. This always happens at 24 hours air-conditioned spaces like hospitals, hotels, data centers, or server rooms. So when moisture is trapped in the paint film, it leads to discoloration or powdery surface. The paint film becomes bubbling and slowly loses adhesion. You will notice paint starts cracking and then peeling off from substrate. And moisture always creates chance for fungus and mold to grow. Therefore, selecting the correct system will help us reduce future maintenance and defect complaints from your homeowners. And these pictures, here you can see these pictures are taken from one of our site consultation invited by a developer. You can see severe mold outbreaks. You can see paint failure over moisture-sensitive ceiling due to intense humidity. This typically happens when the standard paint specified could not survive the actual moisture load in the space. And here you can see thick fungal growth along structural beams, severe condensation damage right under the aircon unit. And this is why proper moisture control, ventilation design, and suitable coating selection are all important. Here's another finding from a different unit where we noticed water leakage issue affecting the floor tiles at living hall. And it caused the ceiling of the unit below to become wet and chalky. So all these are not just cosmetic defects. It is actually a sign of structural symptoms, so which may result in high cost rectification, legal disputes, and may also impact our health and wellness. And to combat all the above dampness issue permanently, we need a dedicated moisture barrier coating. Here we would like to introduce Smart 2K water-based epoxy damp sealer. This is a high-performance coating designed to block dampness. And this formulation is to allow the substrate to breathe while retaining complete film integrity against water pressure. And in order to achieve permanent solution, it requires a very disciplined process. But don't worry, we provide comprehensive method statements with proper surface preparation to architects and contractors. So when you have encountered this issue, it is compulsory to remove existing mold growth with fungicide wash. You have to kill the fungus before you start repainting and ensure the surface is clean, is free from dust before application. Okay. And then follows by Smart water-based epoxy damp sealer. Our technical teams would carry out routine inspections to monitor your workmanship, to make sure they are applying the correct coating system and thickness. And we will also collect few samples for quality audits. Okay, so once painting work is complete, we will verify the total paint consumption metrics and perform visual quality inspections to support on handover and warranty submissions. Our main objective is just to make sure all architects' works are well protected throughout the building life cycle. So traditionally, paints were mainly selected based on color or based on finishing. However, in modern architectural coatings now, we focus on additional functions like low VOC, easy clean, anti-fungus, antibacterial, or anti-efflorescence. And indoor air quality has become an important consideration in building design. Lower VOC coatings help contribute towards healthier indoor space and support in green building objectives. And to ensure product reliability, our products have undergone all certification and testing process, includes Malaysia standard compliance, SIRIM certificates, and external lab test report. Our corporate ecosystem is highly regulated under ISO, so architects can specify smart paints with full professional confidence. And with Smart Paint's technical approach, we have earned a slot in a wide range of projects across Malaysia. Our portfolio includes high-rise residentials, high-traffic commercial spaces, universities, government schools, international schools, and many other government buildings. Industrial buildings with full flooring systems, and complex medical facilities with Smart Paint's healthcare product range. So we hope that Smart Paints has the chance to collaborate with all architects here, and please allow us to contribute in protecting Malaysia building life cycle. Thank you.
Thank you, Ms. Lim. We now know who to find if our project have moisture control issue. We will now move to our first paper of the day. Our first speaker is Mr. Daniel Tan, PAM Group Legal Advisor and Case Counsel, also our Head of ADR Secretariat at PAM. Mr. Daniel is a former commercial litigator. He has acted in landmark cases involving developers' duty and contractual misconduct. He authored Guide to Clocking, a 28-chapter manual officially listed on the Malaysia Judiciary website and widely referenced in legal practice. Daniel now leads PAM's initiative to enhance procedural governance and institutional efficiency in professional dispute resolution. Today, he will be speaking on beyond completion, limitation periods, estate liability, and professional risk. A very warm welcome, please, for Mr. Daniel Tan.
Good morning, everyone. Now, before I begin, I would just like to thank PAM for the opportunity. And you'll be happy to note as well that since I'm the first speaker, my session will be fairly light. I think the second one would be a bit more complex, so it's just to ease you into it, okay? And I'll be dealing with three main topics: limitation period, liability after death, and professional indemnity insurance. Now, there are two practice notes on this already recently this year. I believe it's 2026-2 and 2026-3. The efforts were spearheaded by our incumbent president, Architect Dexter Koh, Honorary Secretary Architect David Teo, Architect Joseph Tan, I'm not sure whether he's here, Architect T.Y. Au from Penang, and a few others. And it is because they recognize the importance of these topics to architects. Okay, and this is aside from whatever technical matters that you have to deal with, right? This is on practice and on how to arrange your affairs. And with that, let me start with the first one, limitation period. Now, the concept is very simple. Just like food, even for civil lawsuits, you have an expiry date. So someone who has got complaints against you must sue within a certain time frame. If they sue after that, even if they file it, it can be struck out. Okay? And the same applies to you. Let's say if you want to sue someone, you have to do it within a certain time frame as well. Okay? And just to clarify, this is for civil suits. Okay? Generally, for criminal liability, there is no limitation period. Okay? So let's one example for, let's say, murder. So someone can murder someone 50 years ago and they can still be charged today, right? And it's because of the seriousness of the offense. And it applies for other criminal offenses as well, unless the government says otherwise. Okay, you have got some criminal offenses where you've got a limitation period, but I mean, it's really the exception, not the general rule. Now, before I talk about limitation period, I cannot start without first discussing about liability. Because if there's nothing to sue about, then limitation period does not have any meaning. Okay? And it's just, in a very general sense, for architects, mainly there are two very broad categories. One is in your capacity as designer. So someone may very well sue you for negligent design. Okay? Perhaps it's not fit for purpose. Perhaps the specifications were inadequate, or perhaps simply that someone might say you did not comply with the UBBL, right? Or it can be from what you have done in your capacity as a contract administrator, right? In the course of compliance with the PAM contract and all. Anything can happen because these days projects are getting more complex. Perhaps it's in your dealing with EOT, it's in your dealing with the schedule of defects, and you can see that the LP, right? And perhaps as the contract administrator itself, some may say that, oh, perhaps you have not been independent, right? That you may have sided with the employer, right? So those are the things that anyone can raise against you, regardless of how well you have done, okay? And I've raised the LP because I would like to stress the point that just because the LP has expired doesn't mean that nobody can sue you anymore, right? It's just a contractual provision to deal with any defects arising during that DLP. So I'll start with building contract. And this is when you are still involved. For the building contract DLP, right? In your capacity as the contract administrator, you know, if there are any issues, you prepare your schedule of defects, you specify that the contractor must rectify, and if he doesn't, the employer can step in, and then back charges can then be prepared. But there may be some issues as well by the contractor. He may say, well, it's not a defect, I've rectified it, so the back charge is wrongful, or perhaps it's the way in which you conducted the entire process. And it's the same with the SPA DLP as well. It's just that you are no longer involved. It's between the developer and purchaser. But if the purchaser were to raise any complaints, who will be the first person the developer calls? It's you. Is it, whose fault is it? And definitely the first thing they'll ask, yeah, I'm not paying for this. It's not my fault. So eventually the discussion will come back to the same thing. Who bears the cost? What's the root cause? Is it a design fault, poor workmanship, combination, right? And that's why what happens in the DLP period will always lead back to liability. And the claimant will always say, okay, who do I then take action against? Now, it's against that backdrop that we consider limitation period and why you need to know so that you know, oh, is this time barred, is it not, okay? For architects, the main two sections are Section 6 and 6A, and they are both in the Limitation Act 1953, and it's also in the practice note already, but it's just to give you more examples of how it operates. And I'll start with Section 6 first, the more straightforward one. Now, for Section 6, it applies to both contracts and tortious claims. When I say tortious claims, it's negligence, okay? Now, for the purchasers, from their viewpoint, generally, the time starts to run when they receive the defective premises. So not when they first find out about the defects. That is immaterial. So once they receive the defective premises, time already starts to run. And that's why, I'm sure some of you here know today, developers will always wait. They'll promise purchasers, oh yeah, I'll fix it, give us a bit more time. And then after expiry, suddenly, oh, we're not liable anymore, but we are willing to pay you an amount on an ex gratia basis. So that's normally their strategy because they are aware of this. They've got a team of lawyers advising them. This is the reason why, okay? Because it happens, you know. So this is just a very simple example, delivery of VP, October 2023, 6 years after, that person would have to sue by October 2029, okay? So regardless of whether the purchaser knows about the defects in the premises or not, time is already running. Now, all of you here are home buyers. You might say, oh, but that's not very fair. What if I really don't know? Then how to sue, right? And to correct this unfairness, that's why Parliament introduced 6A a few years ago. Now, actually, this section has been in place in the UK for the longest of time, but we have implemented it. Now, Section 6A provides that if you discover any defects, you have got 3 years from the date of discovery to sue, all right? And it only applies if the expiry date is longer than Section 6. So if it's shorter, then Section 6 still applies, okay? So in this sense, you know, sometimes you hope that the defects were only discovered perhaps in the 5th year, because if you discover it in the 1st year, then Section 6 still applies, okay? And you then have to take steps to make sure that you know the root cause, you know who to sue and whatnot. Because sometimes, just because you have discovered some damage doesn't mean that you know the defect, especially for water leakage. It can come from anywhere, and sometimes it'll take months before you can actually discover where it's coming from. Or sometimes it's even from a few points, and that's the difficulty with water leakage. And it ties back to Section 6A as well. I say 3 years from the date of discovery, but the law imposes a duty on you as well. So say if you discover like a wet patch, okay, you can't just wait. You then have to take steps to find out what's the root cause. You can't say 6 months later, now I know the root cause, when for the 6 months you did not do anything. So the court in that situation might very well take the earlier date. Because developer will say, yeah, he knew about it 6 months ago, he didn't do anything. So it's not my fault, right? So you can't just sit down. You really have to take active steps as well. And I think the test is to take reasonable steps, right? Based on reasonable due diligence. Right? That means hiring an architect or perhaps an engineer to identify the root cause. If they also cannot identify the root cause, then at least you have a defense. So in that situation, time may very well start later because nobody knows, okay? And this one, same example, VP, October 2023. Oh, sorry, I think it's the previous one. Yes. But you only discovered the defects in 2028, so a year before the Section 6 limitation period expiry. So under Section 6A, you've got until October 2031 to sue. So 2 years extra from the Section 6 limitation period. So that's how it intersects. You've got Section 6. If Section 6A gives you more time, then Section 6 applies, and then you've got your duty as well when it comes to discovery of defects, okay? But then, if you are from the developer, you might say, wow, this is not fair, man. It means if someone discovers a defect, they can sue me. So to balance the interest, Parliament has also introduced the 15-year long stop. So regardless, if you discover the defects, say, on the 16th year or 17th year, you can no longer sue. So tough luck, you just have to move on and rectify the defects yourself. So same example, VP, October 2023. Long stop expiry date is on October 2038, 15 years from 2023. You discover some defects in 2039. Well, you just have to move on. And you have to engage perhaps professionals, but at your own cost, just to rectify the defects in the premises, okay? And this is just a recap. So you've got VP, right, and then it's T, then you've got your defect liability period. It can be between 1 to 2 years, but I just put T plus 2. But running concurrently would be your Section 6 limitation period, so T plus 6. And assuming if you discover the defects at the tail end of that, so it's T plus 9, another 3 years. And then you've got the 15-year long stop, T15. Right, so generally that is the period within which technically you can be sued, or if you are the purchaser yourself, you can sue, okay? And this then ties to part 2 when it comes to liability after death, because, and this is quite a relevant topic, especially for those who have retirement in mind. And you say, oh, I've done so much work, but when I die, what happens, Does it just extinguish? And then my heirs and executor doesn't have to worry. Now, I've got bad news. So it survives. It survives against your estate. So just because you are no longer around doesn't mean that everything is forgotten. In fact, I think it's better for you because you have passed on, but your heirs have to now worry about your liability. Okay? And the Limitation Act applies as well. It's just that when you pass on, there is one additional requirement for tortious claims, negligence, but there's no additional requirement for contract. Okay? For tort, so in addition to the requirement that you have to file it within time, you also have to file it within 6 months from the date of issuance of the grant of probate if you have a will, or if you don't have a will, the issuance of the letters of administration. If someone were to sue your estate, let's say a year after, then it's time barred anyway. Okay? But for contract, there is no such requirement. They can sue any time against your estate, but as long as it's within the limitation period. So here are some examples. Now, for the first example, defective design issued in 2019. Say the defects were discovered in 2022, and soon after, a suit was filed against the architect. And after that, he passed away in 2024. Now, in this scenario, there's no issue because the suit was filed when he was still alive. So the suit continues on. There's no issue about that. Okay, the only potential issue is when it's filed after the architect's death. Then timing becomes very important. So same example, defective design 2019. Then you've got your discovery of defects in 2022. But then the poor architect passed on in 2023, and the probate, assuming that he has a will, was issued in June 2023. Now then, the claimant has to be very, very careful. He has to make sure that it's filed by January 2024. So in this case, if he files it by October, he's safe, October 2023. If for some reason he files it in February 2024, just a month after, then it's time barred, and your heirs and executor can breathe a sigh of relief. Okay. And this is contract, so no difference. Same example, you've got defective design in 2019, the discovery of defects in 2022. Again, poor architect passed on in 2023, and as long as the claimant files the contract claim by 2025, then it's safe. And then that's when your heirs and executor will have to defend your estate on your behalf. Okay. And my third one is on PI, or professional indemnity insurance. And now you can see how important it is, because it's really not about whether you've done your work well. Because even if there are no issues in your mind, anyone can sue you for any reason whatsoever. And it can be a frivolous claims. I've seen a few myself, but then what's the cost? You know, you go to court, you defend yourself, the court sides with you. But then if you don't have insurance, you would have incurred legal costs. So even if you win, but then, you know, you're out of pocket, and it's really quite a Pyrrhic victory, because on one hand, you know, you vindicated yourself, but then you're in the red by, you know, sometimes 6 figures, depending on how complex the suit might be. Okay. Now, just as a brief explanation, for PIs generally, it's on a claims made basis. Okay, so it's not when you are covered during the time when you render your service. It's not that. So as long as the claim is made when your policy period is active, then you're covered. Okay, because it's a common misconception. So it's not when you are covered during the time when you render your service. It's when you are sued. Okay, so that's the material difference. So that's why they always say it's important for you to have coverage, because it's about when you are sued, not when you are covered. Okay? But still, you have to check the particular terms of the policy, because for PI, it's very contract-centered. So there are no general principles, it's just that these are general observations of how the structure is. Okay? And generally, it covers your estate as well. So determined as legal representatives. So if for some reason, you know, you passed on and the policy period is still active, your heirs and executor would just have to inform them of this so that they know who to contact and whatnot. Now, generally for PI, they will cover the defense costs, and they will indemnify you up until the policy limit. So the key also is to have an appropriate coverage depending on how much work you have done. Because if the policy limit is too low, then, you know, you might have to pay for the shortfall if you're found liable. So that defeats the purpose as well. Okay, and just a simple example, you subscribe to PI in 2024, and you continue on after that, and in 2027 you get sued, and if all things go well, you will be covered because the claim was made when the policy period is still active. And if for some reason you decide to end the subscription in 2026 and you get sued in 2027, then everything has to come from your own pocket. Okay. Now, this is relevant if you are planning for retirement, because you're thinking, well, I'm no longer in practice. So do I still have to subscribe to my PI? Because, you know, sometimes the premium can be quite cost prohibitive depending on the size of your practice and whatnot. And you're saying, hey, I'm no longer in practice, income is lower, so, you know, how do I go about it? Now, for some PI policies, they have a rider, they have an extension for lifetime retirement cover. So it's basically the same, it's just that they recognize that the architect can still be sued after you have retired because of the limitation period. Okay, so they have that additional rider, and for some policies, the PI will the premium for the PI will gradually decrease. So perhaps for the first year it's still 100%, because the risk immediately after retire is still quite high. But say in your 5th year, 6th year, you know, chances are if nobody has sued you for 5 years, I mean the risk is definitely lower than the first year of retirement. So that's the idea, but you still have to check with your insurer. Some, perhaps they will still maintain the premium, but perhaps they have got other features as well. So you really have to check. Okay. And depending on your business structure, that will affect your decision as well. So if you're running a sole prop, then you have to make sure that you are covered, because there's no distinction between you and the business. Now, for partnership, there's a slight distinction, because if you are not a partner, then you might not be liable, because the partnership has taken the work, right? But if you are a true partner within the meaning of the law, then you may be caught. Okay, so these questions have to be asked. Are you a real partner or not? If you're a salaried partner, chances are then you're not a partner in the eyes of the law. You may be a partner when they say you're a partner, but the law might think differently. So these are the questions you have to ask to know your position in law and to know whether you need PI or not. Because if the partnership has already covered that part, then you might want to avoid a situation where there's an overlapping policy just for cost reasons. And for limited liability partnership, this is quite a new structure. And for corporate bodies, it's quite similar in that there is a separation. So for LLP, now the partnership can own assets, and the partners have got limited liability up to a certain extent. Okay, so if the LLP is already covered by PI, you might think that, okay, I don't need it. But if you have got personal work on the side that has got nothing to do with the LLP, then you might want to consider having your own personal subscription as well. And same goes for companies. Well, generally, the companies are wholly liable for the works. Directors are not liable at all, okay, unless it can be found that the directors have acted outside the scope of his director duties owed to the company, okay. And same considerations as well. If you've got personal work, that's something to take into account as well. Okay, so with that in mind, okay, what should you do from today onwards? Now, I think our advice is that if you don't have a will already, it's prudent to do so, only because if you are an architect, it's good to appoint an executor who knows what you're doing, and it's advisable if he also has got some professional background. So if anything were to happen, he knows what needs to be looked for and what needs to be done. Okay. And second, I know perhaps for the younger crowd, they have done this already. Everything is in Google Drive, so it's easy. You just give the link to your family members and it's good to go. But just make sure to set it to anyone with the link. If not, no one can click for you. Okay. And if you have hard copy documents, try to digitize it. Or if you find that that's too much of an effort, at least have it organized, perhaps according to projects, and have it stored at a location where your family members know exactly where to look for them in case anything were to happen. Because that's something I see very often. Sometimes all the documents are everywhere, and you just don't know because you never had that conversation with the deceased person. And when something happens, you'll be looking for it in the entire house, in the office, and time is ticking as well, so the stress builds up. And 4, audit your PI policy. So evaluate your business structure and evaluate whether there's a need for personal subscription or whether the existing PI coverage is sufficient. And 5, if you don't have PI, I think the advice definitely is to get it, because it's really not about your quality of work. It's about, just as a society, I think Malaysia is getting more and more litigious, and you see it. The number of court cases on defects alone is on the rise, definitely compared to 10 years ago, say. You see more and more news articles on management corporations and on GMB succeeding in their claims against the responsible parties and so on and so forth, okay? So it's just the general trend. I think we are definitely, in that sense, following the Western countries behind, because they are very litigious, and I think we are heading towards that as well. Okay, and this is mainly for your heirs and executors, so if anything were to happen and you've got an existing PI policy, they need to inform the PI insurer of your deaths, so they have to provide the supporting documents like death cert, or your grant of probate, or if you don't have a will, your LA. You have, I mean, this is not strictly a requirement, because if you don't do anything, it's automatic, but it's good to inform LAM as well, so that the deceased architect's name can be removed from the register. Immediately forward all the cost papers, we call it, all the relevant legal documents to them. Don't be a hero, don't do it on yourself, because that might affect the case and also coverage as well. So let them do it. They'll then engage lawyers for you, and it will be sorted. And fourth, same point, check your practice structure. I mean, this is really for the heirs and executors, so that they know, okay, this is covered by the company's PI policy, so I'm sorted because my dad or my mom used to be a director there when the works were carried out. So it's that kind of conversations that you have to have, both with yourself and with the relevant persons, okay? And just as a recap, okay, for limitation period, you've got Section 6, so 6 years, okay, from the date of VP generally, but different cases have got different starting points, okay, but generally for purchases, it's from the date of VP. And then in addition to that, you've got Section 6A, 3 years from the date of discovery, with the 15-year long stop, okay? And liability does not end with the death of the architect, it survives with an additional requirement for tortious claims. That is, the claim has to be filed within 6 months from the date of issuance of the grant of probate, or LA if you don't have a will. Okay? And importance of PI, do check, and if you intend to retire, explore the lifetime retirement cover as well. Okay? And if you have got any questions, I can deal with them at the Q&A session later, but that concludes my session. Thank you very much.
Thank you, Mr. Daniel. Very insightful topic, reminding us even though our project ended, our liability isn't. Before we move to the second speaker, can I please kindly invite all for a group photos? So can we have Mr. Chris sit down? Photographer. Our next speaker, Mr. Chris Tan, who has been a practicing lawyer since 2000 and is currently the managing partner of Chur Associate, specializing in corporate advisory and real estate matters. He is also recognized as a strata expert and is the author of Strata OMG. Owner's Manual and Guidebook it stands for. Actively educating the public and developers on strata living and management. Chris is a panel judge for the Age Prop Malaysia Best Managed and Sustainable Property Awards and regularly shares his professional legal perspective on building defects, strata law, and land acquisition through PAM and academic platforms. And today he will be speaking on paper titled Strata in Practice, where design meets management reality. Let us please give him a warm welcome, Mr. Chris Tan.
Thank you, thank you. Right, good morning, ladies and gentlemen. Morning. Since they say that my session is going to be heavy, Daniel say wanna, so I dress myself in a pedal pop attire so that, just to keep you calm. Now I've set the tone, remember that song? Pedal pop, in your mind. So I realized from Daniel's presentation this morning, I realized that, you guys are better than Volvo. Because Volvo is Volvo for life, right? Your liability is beyond life, So I'm just saying to you. So later you hear more from Puan, from Lam about, what else you need to do in relation to that. How do you start and how do you end, right? So anyway, thank you for having me again. So I was here, I think, a few months ago for your PDF, also on strata matter. So today we'll actually talk a little bit more details as to what is the reality and what not. So just as the introduction by the MC today about my involvement with the Best Managed Property Award. It's called Best Managed and Sustainable Property Award today. It started as Best Managed Property Award, right? So just let me tell you a little bit of story that is very important, just as this slide suggests. 10 years ago, about 10 years ago, right? So the age actually was talking to me and say that, at that time we got a lot of beauty pageant, right, for property. Beauty pageant, right? Basically we have all sort of name, award in the market. So they come to me and say, I want to do an award. I want to do some property real estate award. But then can we get away from the beauty pageant? Right? So instead of how aesthetically, how design impressive is it and whatnot, so can we not do beauty pageant? So at that time, first thing that comes to my mind when they come to me, we see in the discussion, I said to them, okay, well, our national icon himself, Tun Mahathir, actually, during his reign as Prime Minister and subsequently he did mumble a few words here and there, right? He did mention something very important. He said that Malaysia, first world infrastructure, betul? Right? Third world apa? Mentality, third world maintenance, betul? Third world mentality, third world maintenance. So which means that at that time, that's why he come up with this thing called wawasan 2020, right? Sekarang 2026, tak capai lagi. Close enough, but not yet, correct? So at that time, when they come to me and say, what do we need to do in relation to this award to stay away from all the beauty pageant, right? Then I said, yes, let's look at the health of the building. Let's address the maintenance issue of the building, right? Other than aesthetically pleasing and impressive, who is there to maintain it, correct? Who is to ensure that everything is functional well? Who are the people at the back who make sure the whole thing is functional as the aircon is running, the light is running, everything is run smoothly for the building to come alive. I give them the idea, let's reward property management. Let's reward property management. Hence the award. Now this is 2025. And of course, architects are involved. Obviously, you can see the white hair color that you're very familiar with, right? So Anthony is involved, Architect Center is involved, there's PAM is involved, and every year also we would have judges from the different professions, including PAM, right? To be involved as well. So the whole idea behind that is to say that, we look at building that's already been built, correct? Now the question is, post the completion, post the handover, what happened? So we have categories below 10 years, category then after 10 years, post 10 years. So the idea there is to look at what happened to the building, what happened to your design after it has come alive. Within the first 10 years and after 10 years, during the defect liability period, yes, everything is still under warranty. What if after warranty? What happened? So this is the aim of the award. So I'm very pleased with this award. I managed to encounter what I call in today's context, in today's presentation context, I call it management value. walk in, right, we have problems, right? I'm here today to walk through some problems of these together with you. Is that okay? Do I have your attention then? Okay, let's go. Okay, this is me. Teacher as award judges. This is my award comment for last year. Alright, by the way, I've been in this award for 9 years in a row already. Hopefully they won't take me out lah, inshallah. Right? We'll see. Right? Can I just highlight you? I just want to give you my comment because my comment is very important because that's my observation throughout the year. Right? So my comment here is that considering property management friendly feature, that's very important. Right? You can have the best design, most impressive and look nice, you know, and it might look like it's adding value, you know, things like that, but it must be also maintenance friendly, right? Because in today it's no longer an option or a luxury, because it has to become a foundation of good property development. What's the good of it that you have the most impressive piece of art or building, but it's not easy to maintain? How many of you own a car? Hello? Over you own a car, right? Very good. So you don't believe in COD, right? So never mind. If you own a car, let me highlight to you, when you buy a car, correct? Do you consider the service important or not? Important or not? Correct? You don't want to buy a car where there's no service center. Correct? Very hard to get a part, yes or not? Correct? And then later we have a lot of problems. It might look the most impressive, yes or not? You know, some Continental, you don't know how to pronounce their name, one those car, right? For example, look very good and whatnot, but then you won't buy it because there's no service center, there's no support, right? It's hard to get even a mechanic that knows how to fix the car. Are we clear? Are we clear? So I think that is exactly precisely why we look at property management, right? In this context, correct? Because over the building is also about that you're setting your design actually sets how the community is developed. By the way, Mr. and Mrs. Architect over here, right? Can I highlight to you? You determine the DNA of the building, you know, right? DNA, architect, yes, of the building, yes. So when you determine the DNA of the building, you make sure that you set it right for future development, right? So if I can summarize what I want to highlight to you in really this is this. Property management friendly feature, foundation of good property development, right? Number two is that diverse needs and expectations, right? That's actually why today is a building complex. Remember we keep calling the building as a complex? It's really complex now because everyone got different expectations. The user, yes or not? Last time we say office, we already clear means office means what, isn't it? But today, office can mean 9 to 5, 7 days a week, every day also working, correct? Can mean work from home, yes? Can mean also flexi working hour, can mean morning shift, day shift, and night shift, yes or not? If you do business solution outsourcing, people sleeping, you working. You know what I'm trying to say? So therefore, even a simple office building would have many, many definitions. Yes or not? Even in today's context, residential building, because now even government say work from home, right? The residential building must be capable enough to attend to the needs of WFH. Now it's a government policy. You know what I'm trying to say? You know what I'm trying to say? So I'm just trying to highlight to you, that's why building is a complex, because it's a complex, you know, in that sense. And then whether can it stand the test of time? Floppy disk. How many of you know floppy disk? If you know pedal pop, you know floppy disk. Correct? So dulu floppy disk very big one. Yes or not? Becomes smaller and smaller and smaller, then becomes CD. Correct? And then CD also becomes smaller and smaller and smaller, it becomes thumb drive. Right? Thumb drive now becomes smaller and smaller, it's all in the cloud. Yes or not? So today, going work from home is so easy. You don't have to bring your floppy disk like your CD, your thumb drive, no, even no. Everything is on the cloud. Right? This day you don't know the cloud, even easier, never mind, ask AI. So AI will help you to find in the cloud. Right? So I'm just highlighting to you things are changing and changing fast. How do you make sure that you design a space, right, for the purpose to fit all these changes in? Let's put it this way. way, if I rephrase it in the context of my award judging experience, tell me, if you rephrase it in this sentence, how do you define a space to adapt to future evolution? That's more important. Therefore, it is very important that there is an integration, not only the hardware, but the software, the human element. Right? How do you allow, the hardware is to allow the human element to flourish. Always remember, it is the context that defines the content. But it is the content that gives meaning to the content. Are we clear? Right? So that is why I want you to know why your design matters. Right? Why your design matters. Right? Let me go into it. So strata law is the default development model today. Agreed? Because everyone will make the most out of the land. Yes or not? Density, want to put everything inside, want to connect everything so that it becomes so convenient. Yes or not? Right? If you can do everything a TOD, you do a TOD. Which means you do everything within the complex. Right? You know last time, COVID, we have this thing called MCO. Yes or not? Right? MCO, if let's say it can't happen again, a TOED got no problem. You know why? Because the radius works vertically, doesn't work horizontally, doesn't work vertically. I stay in the TOD beneath MCO. The 15 kilometer thing, I think, what? I hardly move. Why? I go from top floor to the ground floor to buy my stuff. There's a supermarket there. You might own my grocery. I hardly even move. Right? I have all my things. Right? Next to it is the office complex. I got a space there. Correct? So to me, it's all within the TOD. That's why I said, you know, it's defining and redefining the space and allowing that to adapt to the future. Right? That's important. Right? So strata is now the default model. Architects shape long-term outcome beyond completion. We have to understand. And then design decision becomes legal presumption. It was your design thing, but then later it becomes an assumption. What does it mean? Right? It means that you start from an idea, it becomes content of the law. Your house rule, remember? Your bylaw in a strata thing has to be shaped and consistent with your design assumption to make it work, to make the strata community story. So you must have a document or you must have a plan to ensure that whatever is in your mind being translated down to the management, starting from the developer who manage the strata booking, will develop and construct, yes, to the AMD and then later the MC. That's why today we become very litigious. JMB, MC like to sue. Why? Because they didn't get the manual from you as to what it's supposed to do. They look at the way, they say, I think you can do this, then got problem. Are we sure? Are we clear? Hello? Thank you. Strata Titles Act, these are regulated framework that you know. Of course, you know your Strata Titles Act and Strata Management Act and also the Street Rating and Building. So let's put this way, what's strata? Strata is what we call regulated community living. Faham? So it means that before you step into the strata, ada law kan? Correct? You walk into the strata again, got lebih banyak law, extra law that's applied to you out compared to outside. Yes or not? You got your house rule, where to park, where not to park, pay your service charge. Outside you pay tax. Betul? You masuk, you kena bayar maintenance, bayar sinking fund. Yes or not? Right? Kat luar you vote your political party, your bersatu ke, bersama ke, whatever lah. Yes or not? Correct? But you go inside, you also have to vote AGM. Committee members, semua kena vote. So we become very political animal, you know, when we live inside and outside. Are we clear? So these are the things you have to obligate, right? Outside you pay tax, inside you pay maintenance charges. How do you utilize sinking funds? How do you upgrade? For example, one of the simple things that I want to highlight to you, when you design something for a strata plan, can I also let you think that same time when you do the design plan, can you also do a maintenance plan that commensurate with the design that you put in? Betul? So you put in a feature to be this, you have to say how to maintain that feature, how long it to do, how many years later need to be paid, right? What service is required. Then only when the MC take over, when the developer construct and maintain, they know what to do. Otherwise, they look at it, look nice, but I don't know how to clean it. Simple thing. How to fix it, how to maintain it, how to keep it going for years after years. Are we clear? So design is one thing, maintenance manual is again one thing. Right? So this is the act. So Strata Titles Act talks about the ownership. Strata Management talk about the management. It's very important. So you look at it, these two is not separable. In Strata, management is statutory regulated. You know what I mean? It means that you buy this property, it comes with some basic maintenance feature inside. Understand? The rest, whatever is inside, you do yourself, but whatever is outside for the community to share the common property is being regulated, and you are required to pay regularly to ensure the maintenance is in place. Okay? So, let's look at some of the architect roles and responsibilities. Alright? So you look at the design, compliance, ensuring the building plans are adhering to the Uniform Building Bylaws, UBL, right? The Strata Titles Act, local authority requirement, right? Define parcel boundary, wall, floors, and ceiling, and common properties. This is very important. One thing I need to tell you about Strata is this, alright? Strata is all about boundary. Okay, that's very important. Whatever is within the boundary, whatever is outside the boundary, whatever is other people's boundary, right, is very important. That line is very important. Architect, you are very good in drawing lines, isn't it? I mean, that's your daily job, drawing lines, sini line, sana line, yes or not? Right? Do you know that line means something? It's very important. It means yours or mine or shared. Understand? Correct? The ownership, the control, the access. What does the line mean? Means line effectively in physical form, line means wall, brick, door, window. Yes or not? Those are the line that you're talking about. And some of the line is 2D, some of the line is 3D. That's also very important. That is the consideration that sometimes we fail to consider, because once you build, the 2D and 3D become very visible. Right? That's why you need to know what is it. So under here, you have also certification, your role is section 9.1, and then phase development, that's another one. Very important. Strata development in Malaysia did not cater for phase development. Take it from me. I've read the law in and out. It has failed to equip phase development. Why? Because if they have to ask you to file something called the Jadual Petak from Day 1. I know it's not your function. The Jadual Petak is called the schedule of parcel. Those are the land surveyor to do, yes or not? But nonetheless, they prepare it based on what you draw, isn't it? Correct? So yes, so the problem is that your Jadual Petak is not to cover first phase only, Your Jadual Petak is to cover the entire strata development. Let's say you got 4 phases, all 4 phases have to be in. Let's say you don't even know what's going to be in phase 2, phase 3, and phase 4, that is about 10 years later. Correct? How are you going to provide this thing? So you estimate, you put provisional, you put something inside, but then later you have to fit in that mold. You set the boundary by putting something inside. You put the Jadual Petak, just so that you know, the whole Jadual Petak either, how many of you pay tax? Oh, very important, right? Kan, you pay tax, right? Malaysia, how you pay tax? Do you know? Malaysia, very good one. You know how we pay tax? We tell the tax authority, this is how much I should pay tax. Betul? You declare one you submit you cakap, okay lah, I ingat, I kena bayar ni lah. Dia cakap, okay, I terima. Right? Tapi, I have the right to audit you. Betul? 5 years later, you happily pay, you think you pay tax already, right? I can say, you kurang bayar. Kena bayar penalty. You know what I'm trying to say? Jadual Petak is exactly the same thing. They learn from the best. You put inside and tell them that this strata community, I want to build like that. Phase 1, phase 2, phase 3, phase 4. Betul? Right? Then later you tak ikut. Dia cakap penalty. You tak boleh buat ni. Right? In that case, even worse than penalty. You can't even move and shift what you have put tentatively in place for the subsequent phases. That's why you have to think through. right? That's why you have to think through, right? All right? And then next thing, low-cost building, special rule apply, right? Architect shall assign design with state authority classification. What it means is this, I'm telling you, you work within the box, within the limit. You set the limit and you set the box, yes or not, architect, for a strata development. Not only that, before that, you already have to set within the bigger box of what are regulating you. Beside the federal, the KPKT of this world and whatnot, you are also obliged to comply with the state authority as well. But right, state authority have different requirement, yes or not? So again, you are now setting boundary within boundaries. First of all, recognize your boundary. Number two, you then set boundary. But you have to live within the boundary. Welcome to the world of lines. Correct? Just now, Daniel says CA, and CA is what? Contract administrator, yes or not? Correct? Then let me tell you, CA today have a new definition. Remember this, very important. Chur associate. Nama firma aku. Okay? So I'm just saying to you, it's very important that you know what this is. Right, let's go through it. Again, Strata Management Board certification by architect or engineer. Requirement so certified that building and land parcel are capable of subdivision under the Strata Titles Act. Right, based on approved plans and specification. Architect shall use, design, comply with subdivision requirement. Right, non-compliance will lead to penalties. Right. Yes, surveyor do it, but you have to certify it actually comply. Siapa punya liability? You. Right? That's why. The A is always capital. You think Tony Fernandez is only one with capital A? You guys are also capital A. Right? So I'm just highlighting to you, it's very important. Right? Architect statutory touch point in relation to this. You have to define parcel, accessory parcel, and also common property boundaries. Right? And then schedule of parcel, like I said, the jadual, the filing, and the compliance. Remember the tax? You tell them how bad they can audit you. So these are the things that's very important. You are supposed to also look at the superstructure stage certification. Why SSS is very important? Superstructure stage certification is very important. Can I tell you why? Because that is the touch point where strata title can actually effectively be applied for. Understand? Once your superstructure is up, it's deemed that you can determine the boundary already. Okay, you can deem that you can determine the boundary already. Right? Alright, support for proposed strata plan for strata title application. Again, that's the same thing. Right? CCC issuance and the handover of responsibility. CCC is again your liability. But though it's different from CF. CF got authority. Right? CCC got a architect. Yes? So that's why. Important role. Right? Important role. Right? Superstructure stage, you know about it. What's the legal gap here? I want to highlight trigger a 3-month subdivision deadline, but doesn't address the phase superstructure stage. Because superstructure stage, if it's for phase development, you again face an issue. Correct? Which superstructure are we talking about? Phase 1 or the entire strata development? Okay, so the problem in phase development, multiple towers, single SSS logic. Although you have multiple tower, it doesn't have the same logic. Now this is actually the strata development flow for you to take a look. Basically, how you actually do it, approval of the development order, approval of the building plans. Remember, you prepare those things as well, correct? Filing of the schedule of parcel, the jadual peta is very important. If you don't file, the project cannot sell. Cannot sell simply means double sign SPA, double collect deposit. Are we clear? So jadual peta is very important. You must tell them how much you want to pay tax before you can make your money, right? Before you can make your money, right? Then you do sales, and then you have certified superstructure stage, correct? That's where they will have to start 3 months. You have to file the strata title application, right? And then you have to do opening of, then later you have the certificate of proposed strata plan, how to cut the cake, okay? Subdivision to actually issue the different title, and then certificate of strata plan, then you open the book of strata. Open the book of strata means issuance of strata title. Are we clear? So for the phase that you have completed, right, they will have individual strata title, betul? For the phase you have not completed, it's provisional strata title. Okay, can I also test another one? Just now I said how many people pay tax? Everyone say, yeah, we all pay tax. Very good. Right? How many of you see a strata title before? Oi, please put up your hand if you have seen a strata title before. Okay, please put up your hand if you have not seen a strata title before. Homework, boleh ah? I want you to get a copy of strata title. That's very important because it got to do with what I'm about to tell you today. What is the problem you will face? Remember your line and whatnot? Once you look at it, you know what exactly is the problem, right? Okay, so vacant possession versus issuance of strata title is two different concepts. Possession means beneficiary title, I give you the key, I transfer the safety and ownership to you effectively, but legal ownership belum lagi. Kena tunggu strata title. Whatever is in the strata title must have the name of the owner inside. You know, the banking to charge as a mortgage or whatever, and the boundary is being defined within the strata title. Okay, so these two things is physical and really legal concept. It's very important. One govern another. Yes or not? Yes or not? Later I'll tell you what's the practical issue, relation, design, and whatnot. Okay, summary, vacant possession, review, design, and operational problem, issue of strata title, convert those problems into legal reality, right? And then management corporation will then manage the problem long term, face the music at the end of the day. Because strata title property come with strata management, faham tak? So your design don't do well, whatever the problem with your design will translate into a title. You hear me? When it become a title, it become very entrenched. You need to change, I need to go to court. Understand? And then this one here, it will then translate into the management of the entire strata complex. Whatever the problem will now inherited downward and impact the management. That's why your design matters. And you have to think through it properly, especially when you do a strata development. Right? Let me highlight to you what are those. For example, core. This is the core components and boundary. Those people who have actually seen the strata title before, you know that strata title is conventionally thicker than a conventional title. Yes or not? Your conventional title, your land title, conventional title, is actually only two-dimensional. Betul? Right? The boundary of the land. Correct? Your terrace house don't even draw the house. The title of your terrace house only show the land that the terrace house is sitting on. Betul? So the boundary is front, back, left, and right. Betul? Right? They didn't showcase where is the boundary of your building. How it connect to next door. Betul? Tak ada kan? Tak ada kan? In a strata title, what changed now? In a strata title, it's ineffectively showing the drawing of the unit, the so-called parcel, betul tak? So in relation to your condominium unit on the 18th floor, it shows the unit. It shows the cubicle, the three-dimensional. It told about your left, right, up and down, betul? And the boundary is not exactly what you see there. It's the middle of the wall, middle of the slab, up and down, betul tak? So you effectively own a little bit of beyond the ceiling a bit, beyond the wall a bit, you also own. Are we clear? That's why you can drill a hole and put a wall plug or socket there to put your TV, yes or not? To put your fan. Agreed? Yes? So that's why it is very important for you to understand that is the main parcel. But the issue doesn't start there. That's what your understanding is, you know. That's why your communication with the surveyor is very important, because they will then submit and say where is the boundary, where you intend for it to be a boundary. There is a law regulating it, but there's also the design that in your mind will happen. What if in between the slab there is a common pipe serving more than one unit? Correct? What is it within the wall? There is something a common that is serving everyone else, but it's within the wall. You hide between it. Nobody can see. Correct? So the problem is how it look very nice outside, right? Correct? Next question is maintenance. Other problem. How do you fix it? You hack which side? The left neighbor or the right neighbor? Correct? In between the slab one, you have from bawah ke, you have from atas. You know what I'm trying to say? Do you actually give an outlet for you to service it? That's why I said, this is the problem. You buy Alfa Romeo, cannot find service center. Faham tak? You buy Perodua because service center is everywhere. You know what I'm trying to say? Are we clear? Exactly what exactly this is. Right? Next one is the question of accessory parcel. For those of you who have seen the Strata title, have you seen the drawing of the accessory parcel? Ada tak? Yes? Do 2D ke 3D? 2D betul? 2D ah? 2D ah? You agree with me it's 2D, right? So if it's 2D, there's an issue, isn't it? Okay, now we got multi-story car park, betul? Sekarang ada satu peta accessory parcel car park assign kepada saya punya main parcel, betul? Okay? Saya punya kereta boleh, Alfa Romeo saya boleh park sana tak? Boleh. Can I park there? But tomorrow, I want to buy Tesla. Can I park there? Yes. But the problem is, can I put my charging station there? Can I fix my Tesla charging station there for my Tesla car? Now my question is, can accessory parcel assigned to me? Can I drill a hole, put the thing there? Yes or no? Oi. Yes or no? Can I drill a hole or not? No, right? Correct? Because I don't own whatever is beyond that peta. That's not 3D, isn't it? Next question. Lighting on top of my parking. Very bad. Correct? Every time I want to tukar the bulb. Can I tukar the bulb? Who say can? Because you draw it as 2D, atas tu saya punya lah. Because if you say atas yours one, there will be another car park on top and say that's also mine. Kat bawah mah dia cakap ni, alah ini bawah. Betul? Bawah peta saya. Correct? I don't like the fluorescent light. I want to change chandelier. Because my Tesla need chandelier. Boleh? Tak boleh lah. That's why in a strata situation, you have the term AP is always two-dimensional. And what does that mean? Betul tak? That's why I said design, really, you have to ask yourself. Correct? Correct? What does that mean? That's why I said 2D. Right? And common property even better. Correct? Do you know that you don't draw common property in strata title? In strata title, common property don't have a specific, for example, staircase, emergency staircase. You don't draw the emergency staircase out as the ownership of a common property, yes or not? You don't draw the lift. You don't draw the swimming pool. You don't draw the gym out isolatedly. Why? Because in the strata, it's called a law of exclusion. Everything that's not a main parcel, not an accessory parcel, is common property. That's why your facade is an issue, because your boundary of your 3D peta is only middle of the wall outside. Tu kan facade, tu kan common. You didn't extend your line to the wall, to the other side of the wall, yes? Or beyond the wall. Therefore, it doesn't cover, isn't it? So now you understand why is it very clear and your lines matter? Correct? And you have to communicate this because your land surveyor doesn't have your thinking. Dia tak tahu. They look at your plan, they think it's like that lah. Then they submit, yeah. You understand or not? They don't know your intention. They don't know what you hide inside. Agreed? So one of the key things from today, if anything at all within this short period that I've had with you, is make sure that you have constant communication with the person who want to apply for the strata title. Yes or not? You must check very clearly where they put the line, because where they put the line will effectively determine the fate of the entire strata community. That's how powerful the line is. People fight because of this line. Okay? Are we clear? That's why you know why I write my book called OMG? It's intended to mean oh my God. Are we clear? Right? And by the way, you design the DNA. You are the God, my friend. Right? So I'm just saying to you, you have to think through it, the design. Right? It's very important. Right? So shared ownership and shared responsibility. How do you do that? Because in today's context, beyond the line, remember, just to say to you, strata today is very complex one, you know. It's not, line is very important, size, right? Boundary, right? What you can do in and out, yes or not? Today, there's also this thing called the complex. It's called building complex for this issue. Usage also sophisticated. Yes or not? Today we got mixed use development, but correct? So in the mixed use development, there is also weightage factor that assign for the usage in the determination of the ownership of the strata development. It's called share unit. Correct? It's called share unit. Share unit got four determining factor. Okay, write down. I want you to remember. First thing is called size, type of parcel, size, right? Usage. The last one is called location. Empat ni. Can I explain each and every one for you very clearly why it matters in your deliberation? Betul, right? If it's a main parcel or it's an accessory parcel, got different, yes or not? Main parcel got higher factor. Accessory parcel got lower factor. Correct? Therefore, the bigger main parcel you have, the bigger share you have. Yes or not? Usage. Kalau dia commercial, the weightage factor is higher than residential factor. Are we clear? This kind of thing. Correct? Next thing, very important. The size. Because all these sizes are being computed. Even the how big or how small of your main parcel and accessory parcel are all accounted for. Location. Why I mean by location? This is not your KL versus Bukit Bintang kind of thing. No. Alright? The location here is indoor or outdoor. Yes or not? Which one higher? Indoor higher because indoor require more maintenance. That's the assumption, betul? Correct? So why share unit matter? Because once you designated this thing, it becomes very entrenched. Let me give you another example, practical example that we face today. Right? You guys love to give names also. Not only interesting concept, creative concept, you guys also like to give interesting name. So to make it sexy. Correct? Apa itu service apartment? Yeah, thank you. Apartment service lah. Okay. Condominium, low cost flat pun ada service. Hello. Betul, paid service. Siapa tak pay? Mana ada free punya. Correct? You know, service apartment is a big issue. I'm just saying to you, do you know that once you submit the plan, who submit those plans? Building plan, DO plan, who sign? Architect, dia ada tulis apa-apa dalam tu kan? Ada yes, right? They will take those things very seriously. In the strata title, although you don't see, but in the DPKL or the land office record, they would have those words inside. Once you have those words inside, you will determine the utility charges, the quick rent, the assessment, just because you want to make it sexy. Yes, today we got branded residence. Apa itu dengan different dengan service apartment? Apa itu? Branded residence. Service apartment, apa beza dia? Correct? Go 4 season versus 1 season, nah itu saja. Correct? So I'm just highlighting to you all these matters in the thing of how it thinks. So beyond just the line, how you want to call it is also issue. Because it have a long tail effect. Today, I deal with one property in a strata property in downtown KL. Because of the service apartment that you put there, they have to pay very high quick rent assessment and electrical tariff. No matter how hard they try, cannot. And they said, can we change it? The law said individual proprietor cannot. Everyone have to do it. Effectively mean termination of strata plan, you know. Correct? Remember, when you are God, every small thing you do is important. It has long tail impact. Are we clear? Strata OMG. Yeah. Thank you. Right? Let's go. So, consequence of ambiguous design, space not clearly defined, MP, AP, CP, misalignment of ownership, control use, result, dispute and management confrontation, litigation, exposure, long-term dissatisfaction, impacting yield and valuation to the investor, yes or not? Correct? I don't want to buy this because the maintenance cost is high, the electrical tariff is high, because it's no longer considered residential, yes or not? Correct? Because you call it service apartment. Yes? That's what I meant. That's the long tail effect, right? Right? So as far as I'm concerned. So ownership, use and control. Ask yourself, who legally own the space is very important. Right? Determine the strata title and plan, parcel, accessory, common property. Once the title are issued, ownership is fixed, ownership is fixed, is already within that boundary. You want to change your strata title, can terminate the entire scheme. In today's context, call it urban renewal. So you get how hard is it? You understand what I'm trying to say? That means urban renewal, means termination of scheme. Right? If you want to amend. Alright? Very important. Okay? So, key design consideration, who to maintain? Siapa bayar? Who pay? Yes? Who's supposed to do the job? Correct? Who control the access? Access is very important, you know. Remember just now I said, you in between, you put a pipe there that service everyone. Kalau ada problem, hack daripada siapa? Left side ke right side? Understand what I'm trying to say? Right? You cannot say, you know, Malaysia right-hand drive, so right side, tak boleh. Yes or not? Right? I'm just highlighting to you, these are all very important consideration. Accessibility. I went for the award judging, I've seen many times, very nice. Then when they need to maintain, they say, how to fix? Wow, you know, they put one light bulb in a double volume space in the lobby. How to change the light bulb? Scaffolding. Oh. Effectively, you should think about how to access from the top. Atas saja tukar macam tu, from the up to the top. Think about that. It look nice, yes or not? You put a big chandelier there, how to clean? Yes or not? Right? So those are the things that you have to do. Who decide the changes? At the end of the day, if you want to change it, how do you do it? Today, you talk about EV, yes or not? Energy transition, solar power, so many things that's coming here, right? So let's say we want to adopt to those things, you want to change, then who own those things? Who have the right to make the change? The decision making. How do you do that? Yes? Yes? Okay, so some typical issues to show you that car park accessory parcel. Correct? There's a difference with car park accessory parcel and car park as main parcel. Do you agree? Can you have car park as main parcel? Can or cannot? Can. Can. Correct. But can you have car park as accessory parcel? Yes, of course. But then accessory parcel cannot be used for not to serve, can only use to serve the main parcel, tahu tak? Correct? So you put one unit, got 400 car park. Correct? That unit can park 400 car of his own there lah, or his tenant. Yes or not? But he cannot operate and offer to everyone else. Yes or not? He cannot assign. Like for example, I got 3 car park. My neighbor, Hugh, got 1 car park. Poor neighbor. But the neighbor said, okay, can you sell 1 car park to me? Can I sell to him when the strata title is issued? Boleh ke tak boleh? Cannot sell ma, because I need to terminate, I need to change thing of my title to make sure that his title now got 2 car park. And my title got 2 car park. Yes or not? Right? That means termination of scheme. Means ngakomeng, urban renewal. Are we clear? Right? That's why I say to you, that's why you have to predetermine these things from day one. That's why I say I will sell extra car park is only happen when we don't have strata title issue today. Correct? But today strata title have to be applied during construction already. So those decisions have to make very, very early. Not later. Doesn't come subsequently. Are we clear? Yeah. No, so let's go back to the issue just now. How do I go back? How do I go back? There's a lower button, is it? Hello? Can you hear me? Let's go back. And go back. Okay, go back. Go back one more. So I'm just saying that the other one is like, for example, private lift lobby. That's also issue. Correct? Private lift lobby, actually, I stayed in a property with private lift lobby before. What's the biggest problem? Anyone know? Access is a problem. Yes or not? I cannot allow people to tailgate me, you know, in the lift. Yes or not? 2 owner, we must have learned the courtesy because we all know we all are exclusive. It means 1 lift got 1 unit only. Yes or not? So every time, when I go in, with somebody, some stranger walk in, very tension. I keluar dulu ke? You keluar dulu. We got 2 minutes there, you know, I'm thinking. And then, if he insists to stay, I have to reluctantly walk out, although I wait there first. That's the problem exclusive lift. Yes, not this is a practical side. Correct? Next question. Is the landing area belong to me? You have to ask yourself, you draw lah. Correct? I don't know. Correct? And then when the surveyor do it, they have to make sure that it's actually part of the main parcel. Betul? Correct? So those are the things that you have to think, right? That when you do this kind of design. Next one, aircon ledge. Pandai, aircon ledge. Where you put? Outside. On the wall. Do common property. Yes or not? Don't get issue. For example, designated. And post-CC alteration. Correct? And also this thing called landed strata. When you do landed strata, do you draw the building? How many of you have seen a landed strata title? Hello? Yes. Do we include the building? Yes or no? Sometimes yes, sometimes no. Correct? So depend what you want. If you want to include the building, then put it in the building. Yes or not? Correct? That's why I said you decide, not the land surveyor decide. Land surveyor want the easiest job means what? Land easy. I don't have to draw the building. Agreed? Correct. So that's why I said to you, these are the issue. Let's go through each one by one. How many time I have? 14 minutes more or 14 minutes? Balance. Okay, thank you. Right. So, like for example, car park accessory parcel, car park allocation, main parcel versus accessory parcel versus common. Those are the different things. Yes or not? You can actually put it like that. Okay, today we got a lot of issue in this. You know when you draw, right? Right? I'm not sure whether you can imagine the column one. I'm not sure whether you can imagine which wall will go where one. Correct? Right? I visit a site during my award. A car is in between two walls. I said, wow, very exclusive. How to get out? How to get in? The owner every time have to unload everything before he park it. Possible or not? So is it sustainable? No. Correct? But it draws it because I need one more car park. I draw some space there. Correct? Yes. So main parcel and accessory proof of ownership. How do you prove it? For example, it's always attached to the main parcel, but if it's accessory parcel, main parcel means you draw it as its own. Contribution is different, share unit is different. Usage and separate dealing, you cannot have different dealing. Physical boundary, again, like this one, for example. Right? Atas tu siapa punya? You see, there's some duct there, correct? Some service there and whatnot. So obviously you cannot own the top, isn't it? You only own that space, isn't it? Now you know what I meant, right? Now, another one, this is even better. Mechanical car park. Whoa, zzz, move up and down, whatnot, right? Look very changi, isn't it? How do you assign accessory parcel in a mechanical car park? Floating one. Your title comes with some drawing that actually very dynamic one. Can press button to show where is your car park one. Yes or not? So you think about it. While the technology solves the problem, it doesn't address the ownership issue. Yes or not? Correct? You might want to designate your mechanical car park as a common property, so that everyone can have access. Yes or not? And the maintenance could be by the MC. Because if I draw the mechanical park to be yours, you are supposed to do maintenance. Are we clear? Are we clear? So these are the issues that you have to consider with technology coming in. Yes or not? Right? So that's why I want to just showcase this is a very typical issue. Right? Next one. Okay, again, during the right is but it cannot be independently. The answer is not allowed to deal independently. Right? Apply, and you cannot actually on your own apply for the amendment. No. It has to be entire thing. Remember, urban renewal, everything. Right? Commercialization of car park. We have a case. One apartment, 400 plus car park accessory parcel. Car park operated as commercial car park business. Right? Can or cannot? Cannot lah. Right? The unit is a residential unit. How can you do commercial? You understand what I'm trying to say or not? Unless you make sure the unit is a commercial unit. Yeah lah. Thank you. You know what's the problem later lah. Right? I'm just saying to you lah. Right? But you must know it must be intentionally like that. Right? And you must know how to deal with the consequence. Correct? Right? Parking use equal license, not tenancy, not dealing, things like statutory maintenance. So legal survival does not equal functional success. Legally, you can do it. But in function, in practice, you might have a problem. You understand? That's why I'm telling you today, although I'm a lawyer, but I'm telling you what you're going to face in real life. I'm bringing you the management reality, right, of things. Ni exclusive. Access to your unit, welcome, that kind of thing. So, question is, held that there is no need for there to have been labeled affixed to relevant access as designated as common property. It's basically say that in this case, they designed exclusive lift lobby, but they didn't draw the parcel to include the lift lobby. Understand? If they don't include the lift lobby, means the lift lobby is common property. Correct? Your management cost is to cover that also. At the same time, you must allow people to come in also, yes or not? To clean, to wash, to maintain, to change the light bulb. Certainly, you cannot go and put welcome. Betul? So that's why I said, you have good intention, but you have to make sure it translates to legal ownership, access and control. Right? And management reality. Right? Aircon lecture, typical. This is already a good case, A bad case means that wall there also got, upstairs also got a lot of aircon ledges. Right? We just love it. Correct? Service is an issue, yes? Correct? And then later also usage. Can you actually put it like that? Do you need management approval? Yes. Common property facade siapa punya? Betul? Other insurance liability itu jatuh ke macam mana? Yes or not? So things like that you have to think. So when you think about design, you must say, where is it? Today aircon is a must. El Nino, El Nina, I don't know what it is, but anyway, hot, panas, right? So I'm just saying to you, this is the case. Court held that common property is determined by location, not usage, right? So anything that's excluded means that your line, beyond your line, is all common property. Are we clear? Are we clear? Right? Not because how you use it for, right? Okay, so again, AUM Capital versus UA Bangsa, centralized aircon system, benefit common area and selected private parcel, located outside of all the private parcel. So the court held that location entirely outside private parcel means common. So I don't care, even if the common property utilized to use to benefit a few unit only, it is still common if it's drawn out of your privately owned parcel. Are we clear? Right? Let's put it this way. Can I give you the definition of common property? Common property means this. All right? Two or more are entitled to enjoy. It is considered common as long as two or more. If it's exclusive for one, it cannot be even a common property. Yes, but sometimes I do see that there are common property that nobody can access. There are common property that can only be accessed by one. Those are the problem later. Who's supposed to maintain those areas? Are we clear? Are we clear? Right? So again, post-CCC modification. So once CCC issue, any physical alteration is no longer developer issue, where it becomes a strata management and planning control issue. Commons post-CCC changes, ground floor extension, additional toilet landed strata, or even building strata, bangunan, complex, is an issue. Can I give you a very typical real-life issue? I'm not going to name where is it. All right? This is very important. I'm not talking about residential. I'm talking about big commercial building. This guy is very happy. He thought he struck a lottery. Somebody want to buy his shopping mall. His shopping mall is a strata shopping mall. Stratified shopping mall means on top got other complex of building, got other residential unit, got office, got a college there, but the bawah, the podium, everything is retail. Those are stratified owned by him. He thought he sell to the rich, he kena lottery lah, right? And then he thought because he's the owner of the retail, he can do everything in relation to that. Correct? Problem, that's exactly the problem. When they say, I want to approve, I want to buy, then they say, can you show me your strata title? And when they show the strata title, there is a problem. The building doesn't look like the strata title. Why? Because the building was stratified at that time, right, for the retail podium, floor by floor, with certain void area being located very clearly. The building today got one floor, entire the void area, you go and fill it up, put another lettable area there, and make it very gung-ho. So they come to me and said, how do I solve this problem? I said, simple. Can you build the as-built to look like the plan now? Comply, and then ask the whoever will buy it later to put it back later. Because otherwise, you cannot go through bank financing, yes or not? You effectively cannot sell, You thought you own the 3rd floor of the podium, right? You can do whatever you want with it in a strata situation. Because even whoever is helping the extension, the architect involved in drawing it, they don't know. They thought, I got approval, ma. Approval from who? I got approval local authority. All approved, everything good, yes. But your strata title didn't give value to that space. That void area, by the way, if you now put it in, shouldn't be also disturbing your share unit allocation. Yes? Extra, isn't it? You should contribute more for your service charge and maintenance, sinking fund, betul? Now you go and fill up, so what happened? You are shortchanging everyone else, yes or not? Including yourself. So that is an issue. So don't go happily go and renovate. Today we go for urban renewal, so that you understand. To me, also mean this, older building, you go and do renovation. You change the lift, you change the elevator, you change the orientation of the whole place. Very good, very impressive. Problem is, title doesn't recognize. How do you effect it on the title? Correct? If it's a stratified mall. You know what I'm trying to say? Correct? So you have to give due consideration to those things. Otherwise, you are now compromising the value of the property. Are we clear? Now you know your design versus your management and also the reality. Right? Okay, ground floor extension, additional toilet. In HDB, Singapore, sorry, our friend little red dot down there, the HDB, they like to give you extra renovation, give you extra room how they fix a block outside the building and all this thing, right? You know why they can do it? Because in HDB concept, you don't really own it. Yes or not? Therefore, they can do whatever they want. HDB means government. Betul? Over here, tada. Your strata all privately owned, charged to the bank and everything else. So, we are not Singapore. You are on your own. You go and do that, you count him yourself. And then you compromise your strata title again. Right? So again, void area, encroachment, strata mall, top floor, rooftop, attic. This one, seriously, I'm telling you. I used to stay in the 20th floor building. Right? The rent will look like that. At the corner, it slightly go down. I stay in 18th floor, unit number 10 means that at the end, my attic is very big one, One day, I was thinking, hey, I can actually build an attic on top of my floor, so my one floor becomes the double volume, kind of thing. Then later I got problem. I said, hey, better don't do because my title doesn't show in that way. But in effect, if I don't care about selling, I can actually do that. Yes or not? And nobody know. Correct? But I'm just saying to you, this is exactly. You can be innovative. It might look cool, feature in all the architecture magazine, you can win award from there, but then non-compliance in relation to any other thing. Agreed? Yes. Okay, post-CC modification, sorry. Again, extension just now, result, design intent versus living reality divergence, MC inherits enforcement and maintenance issue, neighbor dispute escalate. Agreed? This is what I said to you. What happened is, if you post CC, you still want to change and it impact the boundary, right? So basis of MC objection, they can give you things like, I want uniformity, everything should look the same. Structural integrity issue also doesn't allow you to change, right? Although the drawing doesn't show, but it's a structural wall, you cannot lock it down, bylaw compliance also, correct? I got 1 minute, yeah, very good. Other issue, interflow leakage, facade issue, on block strata, limitation of facade, land surveyor applying strata title, right? So again, most common dispute in strata development often caused by poor vertical realignment of wet areas, shared waterproofing system, lack access for inspection. Remember those exclusive swimming pool? For each unit got one small swimming pool, so one small pond, Belen Yamok, next to it. Then they stack on top of each other, and not aligned one, the water is on top of someone, so you have those issues, yes or not? Correct? So I'm just highlighting to you, yes, it's architectural marvel, yes, look very sexy. Maintenance nightmare. Okay, so now, may I encourage you to do this? If you want to know how this impact you, take a day off, go and second yourself to a property manager to manage strata building. Do it for a week, and you say, thank God I'm an architect. Right? So think like that, all right? So again, Strata Management Act, evidential presumption of defect. So these are the things you have to understand. Like for example, interflow leakage, right? It's always a presumption of the law is that the one on top is liable. Correct? So then you ask yourself, did you design it for like that? Or maybe it is not. What about that? Correct? That's why, this is why you say if you don't put it clearly, it will end up the assumption will apply. Party war, my war with my neighbor, this war is supposedly both our problem. Correct? But what if the problem is from this side or structural or common? Yes or not? So these are the issues you have to ask yourself. Correct? Okay, facade issue in en bloc strata title, very important. En bloc, sexy, right? Whole thing yours. But how do you do en bloc? See, listen, can I highlight to you, in an en bloc title in a strata development, there's still a few ways to draw the boundary. You can draw the peta without the building. You can draw the building very clearly. You can draw the building together with the lift to the basement. You don't own the basement. How about that? Because if you draw it with the lift to the basement, it means the lift is owned by the tower. Are we clear? So again, think about it. How you want to determine boundary, who owns where? Especially make it a very complex one. Alright, I always want to tell about the story of UOA Bangsa. Alright, because I always find it very interesting the way they design it. Who designed UOA Bangsa? Any architect involved here? Tada. Can we learn from them? Is it okay? How many of you been to the UOA Bangsa, the so-called alfresco area and then all the corporate tower there? Yes? Pernah pergi? Correct? Pernah pergi minum-minum and have fun F&B area and whatnot, right? You realize one thing, you park your car there, correct? From the car park, basement car park, you come out to the F&B area, right? Or even you want to go to the tower, right? There's no direct lift one. You take the car park lift to the ground and then take the tower lift to the top. Why? Tower lift belong to the tower. Car park lift belong to the car park. Is it a good design? Yes. For the purpose of ownership. Bad design for user. Why I need to change 2 times? Yes or not? So that's what I want to tell you. Right? From which context are you looking at? Right? So again, evidential presumption, I'm not going to go into that. Right? Basis of, why am I going back on? Sorry. Okay, shared services. How long more? Time's up. Thank you. Right? So just want to highlight to you is that when I look at all these things, you have to think through this thing called limited common property. Because today it's possible for us to create limited common property after strata title is issued. Yes? Correct? So if you design a complex with integrated mixed-use usage kind of strata, you have to think about limited common property. Is it possible? Do you intend it for it to have limited common property? Can I highlight to you? You know what's problem? You know today there's a lot of sub-MC limited common property being created. You all know, right? There are a few projects like that, yes or not? You know what's the problem? After the limited common property created, sub-MC don't have a management office. You know why you laugh? Because you know what exactly the problem. You didn't create the original common property with 2 management office. Satu saja to serve everyone, right? Yes or not? Then later, there's no space in the limited common property to have a space to manage everyone else. Agreed? You know, and then what happened? Sub-MC have to rent from the main MC a table in the main MC office to run as sub-MC office. I have seen many of those. Every time I do a site visit, I saw all, sub-MC, one table, pathetic, poor man. You know what I'm trying to say? Right? Okay, so I'm not going to go to this, like that's just homeless sub-MC issue. Where is exactly the management office? You have to think through. If you have limited common property, you must give them a space to manage. Betul? Yes? Siamese twin, everyone, this is also an issue. Anthony, your good friend, is obsessed with fire prevention. Every time we have to go to every site, you look at all the FCC to see where the fire control panel and whatnot. They will ask the question, hey, this block got fire, that block no ah. You understand? That common no ah. Right? Would they actually accept the signal? Do I ask for evacuation? Most of them not connected. Correct? Most of them, or sometimes very connected, but the other block don't know. Which means got only one. Yes or not? So again, these are the things that you have to put in as a detail, yes or not, today. So I'm just saying to you, that's why we learn this thing called Siamese twin. You design something so integrated that they cannot even form limited common property, which is a strata issue. Agreed? Yes? So you have to ask yourself, do we intend it for it to be separated rather than a Siamese twin? Okay? Right? Visual management 8, very important. Make boundary visible. Sorry, very important. Right? Because you say for standardization, look classy, everything must look the same. Cannot have line. Okay lah, choose different material can. Slightly different color tone. You know, the smart paint this morning say that my tone is consistent. Now you tell them, can I have a inconsistent tone so now can be cheaper or not? You know why? Because I want to separate the common property. Who say one? Chris Tan. You understand? I want to separate the boundary. Which one is individual owned? Which one is separately owned? Right? The light tone that's different or whatever lah. To see that that's visible. That will be helpful. Okay? Things like that. Right? Design for management reality. Building are operated daily through control ways, delivery flow, and shared service. Today, in China today, or even Malaysia today, now every time, every site, we have to ask, how do you control your Grab delivery, your food delivery? Got safety issue or not? People come there, order their coffee, they don't pick it up for one day, next day you throw, you don't throw. You know what I'm trying to say? Do you have policy to regulate that? Okay, what if you got contamination? Yes or not? So these are all concern, isn't it? Valid, isn't it? Correct? Where you put your parcel. These are lifestyle changes that I want you to think of. It's real today. Delivery of parcel is real. Online e-commerce is real. Okay? Home and food delivery is also real. What do you do? Right? Poor alignment during handover and early management usage created long-term conflict. No residents say no to homestay and short stay. 民宿不受欢迎 No Airbnb. They can put the signage there lah. But the underlying title says service apartment, commercial. And then local authorities say as long as commercial title boleh. Tulis lah apa you mau. You know what I'm trying to say not? Correct? That's why I said you have to understand. A lot of people don't know what they are getting themselves into, but you know. Remember, oh my God. Thank you. Right? So final takeaway, architect role extended beyond completion. Document as risk management, very important, right? I mean, I don't have to scare you about after post-completion. Daniel have actually scared you enough in relation to that, right? Clear drawing, clear ownership, very important. Architects shape the trust, usability, and long-term harmony of the entire strata community. Are we clear? Strata is a design condition, my friend. Right? It's not a post-design legal exercise. Are we clear? That is the message I have for you today. Right? So with that, thank you very much. You can like Chur Associate on our Facebook. This is me, follow me. And you can reach out to me. That guy look like me, sound like me, is me. Right? You can reach me at kristan@churassociate.com. Thank you for your attention.
Welcome back, everyone. We hope you have a very refreshing tea break. Feeling also? To continue our morning session, please join me in welcoming Miss Crystal Tay, Assistant Spec Development Manager of Dongji Sdn Bhd for their presentation. Welcome.
morning, ladies and gentlemen. My name is Krista from Pentens. It's my honor to be here to represent Pentens, the chemical specialist company, to present you about our green virtual car park system. Today, I'm going to cover a little bit about our company background, car park flooring system, the importance of moisture barrier, application process, and lastly, our project reference. Before we continue, let me show you a short video to introduce our company.
Pentens, established in year 2000 through its wholly owned Dong GM Sendirian Berhad, is one of the leading manufacturers and distributes specialists in building material for all industry, which includes waterproofing material, car park and industrial flooring, raised floor system, and chemical grouting material. Business activities of Pentens cover the full spectrum of project types, ranging from infrastructural development to building, from institutional facilities to manufacturing plants. Our services direct customer, main contractor, and distributors and stays close to them via the Central Sales and Marketing Office located at Selangor and Network Branch Sales Office in Penang, Perak, Johor, Kedah, Pahang, Malacca, Sabah, and Sarawak. The key vision of Pentens is to improve quality of products and services through dynamic and innovative management, as architects and engineers are constantly searching for new innovative ideas and design. Therefore, our group is to assure our products meet superior quality, versatility, durable, and reliable. Our company has also increased its research and development activities in all facets of product design, innovation process such as Industrial 4.0 revolution, gearing it to move towards the production with greater value-added products, as well as improving current production techniques and process based in Taiwan. The mission of Pentens is to create environmentally friendly product, as our company aims for a better living society and a wholesome environment. With the achievement of Singapore Green Label, ISO, CIRAN, SGS, LEED recognition, Pentens seeks to continuously provide quality products and engineering services to all levels of industries in Malaysia. In this era of Go Green globalization, Pentens further to research and evolve ecological design, energy efficiency, waste management, and indoor environmental quality. Simultaneously, Pentens also look forward to reevaluate entire value chain in order to contribute towards a sustainable environment.
Okay, our raising flooring range covers everything, from car park system to industrial, and also specialized solution like anti-static and sports coating. Why floor show car park system, and what is it? It is a full PU car park system that laid on the concrete flooring. It is in low VOC, and the properties of watertight surface shall be able to protect the floor from corrosive chemical, heat, and UV light. It also brightens up your car parks and create a comfortable environment to the user. And it is also certified by Green Label. What are the other benefits to have a PU car park floor? It is anti-skid, many color to choose, easy to maintain, and it will protect your substrate from impact, abrasion, and chemical. We cover all types of car parks. We have systems for internal, rooftop car parks, outdoor areas, and basement. only smooth finish. These are the floor finishes that we could provide based on the requirements. Let's dive into our internal car park flooring system. Okay, this is for parking bay system. It comes with a layer of primer and then fluoro oxide with a very fine aggregates with 50 to 100 mesh, and we will finish it with 2 layers of UV resistance coating. And this shall be the image for the parking space. As for the driveway, it's provide a textured finish to improve the abrasion resistance to the floor. So this is how it looks. As for the ramp area, it will require more coarser sands to create a very rough surface in order to provide a better grip to the tires. Therefore, 1630 mesh will be proposed for this area. And this shall be the image for the ramps. Okay. Next, I will talk about the external car park. What is the difference between external and internal car park? Why can't we use the internal car park for external? Actually, the finishes are the same. But it has an additional layer of the waterproofing membrane because external car park exposed to rainwater. So you can see from this system breakdown, they will have a layer of flexible waterproofing membrane before applying the car park system. Yeah, this is the waterproofing membrane. Okay. And also for safety purpose, it is good to have all textured surface for both driveway and parking bay for the external car park. So this is the parking space. Okay. Nowadays, a car park coating doesn't only protect the concrete floor. It also increases the property value of one building. Client can sell higher price for the building, or the car park fee can be higher. A decorative car park marking or linings could bring the car park environment to the next level. A car park looks more comfortable and attractive with different design and colors. With pendants, we can also add signages, logos, and design to make it look more atas. Yeah. Not only on the floor, we can also coat on the pillar as well as on the wall. Okay, next I will talk about what is the moisture barrier and why the moisture barrier is important. Have you ever seen this kind of problem on your floor before? The PU or epoxy flooring full of bubbles or peel off easily. It usually happens on the touching ground slab or lower basement. You will see some water or you will feel the dampness when you open up the bubbles. This is because of the uprising moisture attack from the ground soil. Bear in mind, PU flooring is watertight from surface, where the uprising moisture from the ground would not be able to breathe through the coating. Therefore, the moisture would attack the weak point, and then you can see the bubbles on the surface. In order to solve this issue, Pentane's E502 need to be applied before the coating system for all touching ground slab. Pantene E502 epoxy mortar is a permanent moisture barrier when you apply at 4 to 5 mm thick. It can allow the moisture dissipate through the epoxy mortar and not having the issue that mentioned earlier. Next, I will show you a short video of the step of the application process. This is the epoxy mortar, which is the moisture barrier. We will compact it by using this power float machine. Then we will apply a layer of sealer coat after the epoxy mortar. Yeah, this is to make good of the surface. Lastly, I will show some of our project reference list. Yeah. This is the TRX car park. Okay. Affin Bank in TRX as well. HSBC in TRX also. Yeah, and you can see this is the combination of the concrete floor and the PU flooring. Yeah. So you can see they did not apply in the full system. So this is the ladies parking, and this is EQ Hotel. EQ Hotel, the ramp, they did not do the groove line, so the ramp will be very, very rough. And then this is the Bank Raya. Nirvana. Then these are some of the buildings that they are actually using our car park system. Like the Kuala Terengganu, Cyberjaya, and this is the TRX that we show. And then PHP building. This is a Johor CI Medini, Avenue K. Yeah. Okay. Lastly, please contact me if you do have any inquiry for the car park flooring. Thank you, everyone. Thank you.
Thank you, Miss Crystal, on the very informative car parking flooring system. Our next topic is one that relatable to our practice. It is my pleasure to introduce Architect Sharina Intan Abdullah. Apart from serving as Senior Director of Architects Department at JKR Headquarters, Malaysia, Architect Sharina is also the Chairperson for Registration and CPD Committee of LAM 2023 to 2025 and also 2025 to 2027. Trained as a professional architect in the government sector, she has been involved in many KKR projects, especially educational and health facilities projects. She currently heads the Architect Department of JKR Malaysia, overseeing architectural service for Minister. Previously, she was also the Director in Development Control Consultancy Unit, Local Government Department, Ministry of Housing and Local Governments. She has embarked on the improvement of the OSC 3.0 manual program since 2017. The improved manual OSC 3.0 was rebranded as Manual OSC 3.0 Plus. She was also initiated as the OSC 3.0 Plus online system that complements the manual OSC 3.0 Plus. Today, she's going to present From Registration to Cessation, the Practice Life Cycle in Malaysia. Let's give a warm welcome to Architect Sharina.
I thought it's only at the ground floor. Now I can see it's also upstairs. Okay. Assalamualaikum warahmatullahi wabarakatuh. A very good morning to everybody. So as been mentioned, I am the LAM Registration and CPD Committee Chairman. So the topic for today would be the life cycle of practice in Malaysia, since I'm also the chairman for registration. So from registration to cessation. Where? Where do I? Here. Okay, here. Oh, there. Okay. Anyway, going back, most architects don't fail because of design. Yeah? We are good designers. That's why we become architects. But we fail because of compliance. So, as I see quite a few numbers of architects here are the young ones, but also the older generation, as I can see also a few. But we are no longer just a designer. You're also running a regulated professional businesses if you have ACP. Oh, sorry, wait again. Where to push? There, exactly here. Oh, there. Okay. Tak ada pun. Tak jadi pun. Tak jadi pun. Tak comply. They fail because of compliance. It doesn't comply. So we are good designers, but compliance even for this thing is not happening. I think you have to do it. You have to do it for me. Anyway, just to highlight, prior to waiting for the presentation, I'd just like to highlight that I presented a paper last year during Datum LAM and PAM event about succession for ACP, and to highlight about the numbers of architects in running the business. Thank you. We have about 50%, or I think slightly more, that is more than 60 years old. So can you imagine the numbers of, I can say the older generation that is actually leaving. I know quite a number of companies, ACPs, are actually leaving to their heirs now. So this paper that I'm presenting can relate very closely to that. I hope whatever that you can take from the paper, from the presentation, you can take it. But at the same time, please plan accordingly. The one that just now this morning, Mr. Daniel mentioned about coming up with a will, very, very important. Yeah, because if anything happens, even when you're in your, basically when you've been passed on, the reliability is still there. All right, okay, we go. All right. So anyway, the legal backbone, the law, everybody knows about the law. The Architects Act 1967 governs the profession and protects the public interest. No doubt about that. The regulator, Lembaga Architect Malaysia, Board of Architects Malaysia, regulates and conduct and discipline. That's the role of the board. So quite a number of people also get confused between LAM and PAM. And whenever there's any issue, they go like, what is LAM doing? What is PAM doing? What is ACM doing? Everybody is putting the blame here and there. But I think at the end of the day, Lembaga Architect is the regulatory body. So whatever that we use for, they call it the Punca Kuasa, the law is the Architects Act. And the vehicle for to come up with the architecture consultancy practice is through the ACP, a legally recognized entity for offering services. Okay, so the architecture profession operates within a design control. I think all, especially for architects, we have the Architects Act to regulate, as a tool to regulate for all architects, be it for registered, be it for graduate architects, ACP, interior designers, also for AT, architecture technologists, and also the registered building draftsmen. Okay? So the legal backbone, as I mentioned just now, Architects Act, revised 2015, and Architects Rules 1996. So it's an act and rules to provide for the registration of architects. So we have a register, and also the register for all ACPs, sole proprietor, partnership, body corporate, body, and also AMDP. And then the Board of Architects is all registered as shown on the slides. We register, we manage the registration, we regulate the professional conduct and ethics, and we also have disciplinary action against breaches or misconduct. So we do have a disciplinary committee in the board. So it's not to restrict the creativity, but to safeguard public interest. At the end of the day, the act is to safeguard and ensure safety and uphold professional standards. That's the difference between Lembaga Architect and PAM. PAM is doing all these activities to help also to make sure that all architects understand when it comes to practice and other things as well, not just practice, but others as well. We even have a equity, what do you call that? The Heritage Committee. We have many committees in PAM. It's a matter of whether architects would want to register or not with PAM. But I hope there will be more numbers, especially for within the government sector, sorry to say. The numbers of government sector is a bit less, I think, in PAM, but I think we are going towards, with the discount given for the register, for the renewal, it will help. I hope it will help, all right? Okay, next, we go to the legal ecosystem. So anyway, everybody knows you have to go to your part 1, part 2, part 3 prior to coming up with your ACP. So once you are registered as an AR, a registered architect, then you can manage, you can open up a company with your ACP. So most of us are trained, as I mentioned, most of us are trained in design. But we must also quickly adapt to the law, finance and management. Coming with ACP is not just managing design, managing the practice, but also the finance part as well as the management part. Okay? And of course the base will be the Architects Act and Architects Rules and Board of Architects, okay? These actually show the one they mentioned just now, part 1, part 2, part 3, and the reality, the practice life cycle. Okay, so anyway, for the young ones, your leap is abrupt. Once you have finished your professional architect, you're registered as a professional architect, you open up your ACP, the leap is abrupt. You are launching a regulated enterprise, not just a creative studio, okay? All right, so this is the breakdown in the Act and also through the General LAM Circular 2023 on the types of practices allowed under Section 7A, Act 117. Sole proprietor, where normally the firm names will be the individual names or the full part of the respective architect. You can also have partnership, architects only. The firm name must also not be pretentious or ostentatious. This is what the words that we use exactly from the Act. Okay, sole prop, partnership, and then the other is the body corporate practice. Now we can have from the 2008-14 starting, we can have single director. Previously, no. But from now, 2014 onwards, SSM have already come up that we can come up with the single director. So single director, of course, only one, that will be the architect. Can have multiple directors, so all architects or combination of architects must be 1/3. 70% of the shares must be architect. The 30% or 2/3, there's now the architect is 2/3 and the 1/3 is any person. So any person can be anybody. Okay, the committee, the registration committee sits down on this and we will vet through when it comes to the shares and the directorship for the ACPs. And the trend now is that a lot of the sole props are going towards single director. I think it's quite obvious. Of course, when you have when you are the body corporate, the liability is limited to it doesn't go to your personal liability. So that's why the trend now is more of that. And in fact, I think quite a few projects, even government projects, we are having the consultant have changed from the sole proprietor to body corporate. Only thing, when you do all these changes from sole prop or partnership or body corp or whatever, please also inform lembaga. Of course, you have to inform lembaga because you need to go to the lembaga, but as well as the local authority. Because we have a letter from a local authority asking about things on this. Local authority and yeah, I think that's about it. SSM, of course, you have to deal with SSM. Yeah. So anyway, so the minimum paid up capital for body corporate is 50K. Okay. Just now we were discussing. I think somebody mentioned have to fork out 50K for body corp. When you first start, where you get the money? Things like that. It's up to the individual. If you have the money, by all means, you go for body corp, single director. If you don't, you go for your sole prop. After you have been you establish already your company slowly. Once you have already got a few projects, when you are more stable, then why not? You can move to body corp, because in our registry we can in the Act says that you can have any two of the ACP. So let's say you have body corporate and you have as the same sole prop and body corp, okay, that's okay. Or body corp, sole prop and MDP. Oh, there's another one. MDP is okay. You cannot have at one go, or rather you cannot have everything at one go. You can only have maximum 3, but the NDP would be so prop name and then the MDP. Yes, that's right. Okay, so anyway, your firm name must not be pretentious or ostentatious, as you can see there. Okay, here, and then this is another one, multidisciplinary practice. Here, the board of directors can be architects, professional engineers, or registered quantity surveyors. So the combination share is 70% of the overall equity of the body corp. So that means yours can be minimum 10%, minimum. And then maximum share of the other 30% is other person including or belonging to a profession allied to architecture, engineering, or quantity surveyor. You can see the difference. Multidiscipline, you must have that 30% that is allied. Whereas just now, body corp, the director, the 1/3, that 30%, not necessary. So sometimes they have sometimes they can even have, recently we even have a developer who is taking the shares of 30%. According to the Act, it says okay, it's okay. But when it comes to integrity and all that, of course, there's a concern. So we still proceed. But if there is any case later, because when that happens, that particular architect holding the 70% should not take the projects from that particular developer. You see? Because you have to understand on that, because the relationship, you have to be impartial. You cannot have doing the projects for that particular developer, that particular architect, right? So minimum here, the minimum capital is, paid up capital is 150K, right? So anyway, this is summing up to what I mentioned just now. Standard practice model, section 7A, according to the Act, is the sole prop, partnership, as well as body corp. The body corp, you have to have the minimum paid up capital 50K. Multidisciplinary practice, section 7B under the Architects Act, you have to have the paid up of 150. And you can see there, the comparison of sections, basically the amount paid up capital, the difference. And you can see also the shares, okay? Right. So, the ACP is your absolute legal parameter. I'm just showing the one from under the LAM. So, prop, partnership, body corp, multidisciplinary. But on the registration of a company, SSM, it's the same thing. It's enterprise, which is same like body corp, sole prop, limited liability partnership, and the company is under the body corp and multidisciplinary. These are the yellow ones is the one that needs to be registered with ROC. Okay. Only difference is that we call it ACP under our acts. Okay. So here is what I want to mention on the regulatory. LAM enforces regulation with statutory power. Here is where under the section 15.2, 15.2, Act 117, our Act, the disciplinary committee may order the issuance of a written or reprimand cases. For everybody's information, I mentioned just now, we have a disciplinary committee in LAM. We have many, many cases. Lots of cases. Majority of the cases are about defects, relating back to Mr. Daniel's presentation earlier. A lot of defects. And majority of the time is the house buyers and even association of house buyers. They come up with a group of them and complaining about the defects. Because somehow or another to them, they have already made complaint to the developer. They have made complaints to KPKT, but it doesn't work. Complaints to KPKT, complaints to local authority, developer and everything. But to them it's a bit difficult probably because the governing body for this under KPKT, it may take time. I'm not sure about that. But basically they would also they will try to penalize the PSP. And they will go normally they will go, how come CCC is issued when there's so many defects? Can you see the relationship? CCC is not about defects, you know, but to house buyers, they don't see it. They say, who else can I get to do to bring their cases up? So normally, the board will ask and inquire from the respective architects what they have done to make sure that the defects are rectified. So even though it's not your responsibility to make sure, it is your responsibility to make sure that the defects is rectified by the contractor, developer. And you have to monitor the status and all that. That part you have to do it as a professional. Diligently you have to practice to make sure that it's been done. Okay? Because the board will look into that. The board will not, in this case, will not say that it's entirely your responsibility. It's not entirely your responsibility because the responsibility to rectify the defects is actually under the developer. But at the same time, you must also diligently make sure that it's covered, that you have already monitored that it's been done. Okay, so anyway, the maximum suspension period is, according to the Act, 3 years. And of course, if it's still not been ratified, because we do also have cases, lots of cases, where it goes to even the police, it has become a police case, there's fraud, there's many things, so it will be up to the level of removal from the register. That means you cannot practice. That's why we put there total structural failure lah. cannot practice under Section 16 Act 117. Right? Okay, here is about the single director, the one that I mentioned about the body corp. So in a way, it is good that the sole prop is going towards the single directorship, the sole proprietor going towards the body corp, because your liability is limited to the company. So in a single director setup, the director enjoys limited liability. It doesn't, because the company is a separate legal entity. However, the director is still exposed to personal liability for corporate debts. So anything to do with the company, you are still liable. But anything, you will not incur into your personal belongings, your own hartana and all that. Not like the sole prop. The sole prop, it will go after, really go after whatever that you have. Okay? So that's why a lot of companies, the sole prop is going towards the, the sole proprietor going towards the body corporate. All right, so there's the directorship duties. Of course, you also have the ACP responsibility as well as the professional liability. So please take note on this. Okay, unfortunately, under the statutory process for Companies Act, Section 209, under the Companies Act 2016, the trap is you cannot resign if you're a single director. Because the thing is, because if you are left with a single director, the director cannot resign at their whim and fancies. You have to get the burden to get the next of kin is through the company secretary. So let's say the death of the sole director, and you are the only remaining director, you have to find another one as soon as possible. Or not, if not, then the company secretary will be the one who will have to, as soon as practicable, to call a meeting of the next of the kin for our professional representative. So that's why, to me, it's always important if you have a company to get your will or your family members know what's going on. Like what Mr. Diana mentioned, they must know what is your succession, what is your planning for future, because you cannot just expect it will go as smooth as possible when you pass on. It's not as easy as that, you know. And even if you have a body corp with a single director, you have to go through all this, and it's not easy. You need to get a company secretary to call a meeting, and this and that. So anyway, 6 months strike off after. If you still have not get the what do you call this, your heir to take over the company, then it will be strike off. Yeah. So please take note on that. All right. So real disciplinary matters. I mentioned just now on misconduct. Of course, there's root cases, the impact and penalty. So some of the misconduct that we have is on certification misconduct. Premature certificates. Yeah, there's quite an house buyers nowadays are, how to say, more litigious. They are aware, they are more aware, and they're more litigious, and they go around and take pictures, and they'll send to the board pictures, even to the local authority pictures of, by right they should not even come up with an interim cert that says this and this. They even go to that level. And that's where we have to call the respective respondent, the architects lah, to find out more. Okay, and there's also on the misconduct of selling signatures. Unfortunately, I encounter few cases. Maybe because the awareness, I think the awareness of the director of about selling signature. There was one architect, he mentioned that he did not know that his so-called staff forged his signature for submission, for interim payment. He doesn't know. But the amazing part is 17 bungalow projects is signed Can you imagine? 17 bungalow projects is signed and he doesn't know about it. So how does he manage his office? I mean, I did ask that sort of question. He said, no, and, you know, lots of reasoning. But that's where I said there's something wrong. So I said, that's why misconduct. And of course, misuse of title and fronting. That's also another one. There's a few architects that we think is quite well known, splashing all over in the media that they are the world-renowned architects, this and that, whereas they are actually graduate architects who have deregistered themselves. We have that. I don't know. Anyway, as I said, these are things that we know the causes, as I mentioned earlier, pressure from developers if it's certification misconduct, pressure from developers, poor site verification, selling signatures, easy income, like I mentioned just now. He doesn't know that his office has signed. How can that happen? And the payment is to the office, and he doesn't know. Pelik, right? Pelik and ajaib. So things like that. I mean, I just cannot jive on that. Anyway, easy income, external collaborations, and of course misuse of title. So they are also scammers lah in a way. There's also scammers who act to act as an architect, but actually they're not. So we have to be careful in that as well. So of course the impact and the penalties, you can see there, client financial loss and LAM action, of course for the certification misconduct. Selling signature, the liability for the design. Can you imagine that particular architect said he did not sign, but it's already submitted, built, built, and getting the payment. Who is managing the design? Who's managing the construction? So that's why I said liability, full liability. And of course, when it comes to title and fronting, complicity in illegal practice. Okay. At the end of the day, loss of public trust. Yeah, as we can see now, the public is more aware of respective roles of the professionals. So when we don't do it accordingly, professionally, we lost the public trust. So anyway, I mentioned down there, your signature represents ownership, control, and absolute responsibility. So talking about responsibility, I actually asked Mr. Diana this morning about CCC. Probably later you get questions on that. So, but just now it was on liability, the liability for the defects, right? So how about when it do submission for CC and you are the principal submitting person? How long is the how long that you manage you are responsible for the building? That's the question that I actually would like to ask Mr. Daniel. Okay. So anyway, so the disciplinary cases are predictable failure patterns, not accidents. Not accident. How can that particular architect I mentioned just now think there is an accident? And he even made a police report. He even made a police report saying that somebody from his office forged his signature. Okay, if it's one, okay, 17. So it doesn't matter anyway. So big system, practicing without valid SCP, of course that's even worse. We have a lot of illegal, I can say illegal practice, especially architects we do have, but especially interior designs. We have a lot of that as well. The difference between interior design and interior decorators. So there's a lot of misconception as well in the public because they think that interior design, they can just hire anybody to do interior design. Not really. Yeah? Okay, I think even what do you call this? So-called IBS supplier, developer and all that, who can build houses and automatically submit for you and get it done, you know, things like that. We question on that as well. Who is the one who is actually the principal submitting person? And many house buyers who buy these sort of things, finally their houses are not even completed, quite a few. Yeah? Famously, some artists are having that sort of problems. All right. So when there's a compliance failure on the weak system, giving example, practicing without valid ACP, ignoring ACP renewals, that's another one. Overspending on setup. Just now, Chris mentioned what you said, cantik-cantik design, cantik-cantik. So new, cantik-cantik office, cantik-cantik. When you first set up your office, cantik-cantik, put everything. So you splash a lot of money there. But then once you want to really practicing, there's a limited of your funds. That's the thing, yeah? Overspending. Poor financial discipline, there, taking loans too early, expenses exceeding revenue, ignoring cash flow, and lack of governance there. Selling signatures, poor certification practice. That's another thing. Collaborating with illegal practice, of course, is even worse, and treating ethics as optional. So all this will create the disciplinary risk, the yellow color there, right? Okay, so sustainable practice. This one relates to just now, the regulatory discipline, financial control, ethical leadership. I will not touch too long on that. All right, now for the professional discipline. CPD compliance, please comply with your CPD compliance. I know normally we try as much as possible to comply. That's why we attend this thing, right? At the end of the day, thank you, PAM, coming up with all these CPD programs. I think ASM as well. ASM is also doing so CPD compliance. But at the same time, there are also a few who have got problems to acquire their CPD. Never mind, you can always discuss with the board, because it's also on health issues and all that. So it's okay. You can always tell the board, put it in writing, and we'll consider. All right, and then code of conduct. Of course, there's no other way. You have to maintain your code of conduct. Integrity, transparency, and the overriding duty to the public at the end of the day, right? Okay, now we go to the final protocol, the lawful cessation of practice. I was mentioning just now on the registration, now we're talking about on the cessation. First, you have to notify to LAM and relevant authorities, the local authorities, SSM if it's about the body corp and all that, regarding the intent to close the ACP, right? But as I mentioned, normally we would like to pass it to our heir, if we do have an heir. If we don't, we have to find somebody, right? Or you want to really totally close down your sole prop, by all means. But there's a lot of things that you have to manage, like what Mr. Daniel said earlier. The liability is still there. When you want to close, when you want to do anything, there's still a lot of liabilities. Your projects, is it on site? You have finished the project, what level is the project? All that. So the continuity, so fulfilling all remaining statutory responsibilities and active contract obligations, right? And then to transfer. Sometimes seamless transfer of ongoing matters, the drawings, and the, as I mentioned, liability to the new registered entity, whoever it is. And we have to also manage the client protection, ensuring client interest. All this information you must tell your client also at the early stage as well. When you plan, when you want to plan, you have to inform the client. So we hope that all these things is done well, so that at the end of the day, hopefully, there will be zero liability. As I said, hopefully. Because if, like what Mr. Daniel mentioned just now, 6 years down the line, or even 50 years down the line, oh goodness gracious, we hope there is no problems that arising later. Okay, so LAM deregistration, especially for the ACP, the directors who have already passed on. So the Section 16 says, Architects Act Section 16 says, automatic removal from the register of any architect who has died or ACP which has ceased to practice. So the proof, you must prove the heir. The heir need to prove the spouse, the heir, relative, or client, even worst come worst, client must submit the death certificate to LAM. Without it, cancellation cannot be confirmed. We need some proof. The board needs to some proof. So the onus is entirely on the family. Or worst come to worst, there's also cases where the client is the one who actually mentioned because they need the letter of release. Yeah, sometimes the family do not have an idea what to do. When you have not mentioned anything to the family, and something has already happened, pass on. So the family have got no idea. So that's when the client is the one who wants to get the letter of release and inform to the board. So the arrangement. So ACP cancellation depends on the heir status. The heir, let's say, the variables can include the heir has no one to take over, or the ACP has got no one to take over. The heir has a qualified family member, alhamdulillah, okay, good. Or the heir wishes to transfer rights, or the ACP has surviving partners. So there are many variables, so it depends. I think it's, as I mentioned earlier, put it in the will. Put it in the will. From the beginning, you know that what you plan for before anything happens. All right, so this is the decision protocol to the heir if it happens that the architect has passed on. Family notifies LAM or client, nobody mentioned just now. So it can be the heir himself ignores, probably he doesn't know, or the heir seeks remaining fees. He has to do all this. And or the heir wishes to take over. Alhamdulillah lah, if there is somebody to take over. This is the path for the heir, which one he wants. Okay? All right, so anyway, the handing over mechanics. This has got to be thought through. Yeah? So if it's a schematic design, the professional action that should be done with schematic design, that means before building approval, building plan is approved. So what the heir needs to do, or whoever who is taking over, what to do. Advise the client to obtain letter of release, waiver from LAM. Confirm the letter of release and agree on appointment. Determine remaining scope and fees. The phase 2, the contract documentation, yeah, after the building plan is approved. I would like to highlight on the yellow color. Please inform the PBT. Apart from LAM, of course, inform the PBT because it's all about the local authority when it comes to building plan. All right. Okay. This is right. Next, on during contract implementation, more advise the client to inform purchaser of architect change. Certify remaining progress billing or SOP. Okay, so do this. This is what needs to be done during contract implementation during the construction, and then of course the final completion before CCC is issued. Please administer accordingly. Right? Okay. So there are a few architectural typologies of succession. Mentioned just now, family succession. That's the easiest. If you do have family who wants to take over, or you can also have partner buyouts. Your partner would want to buy out. Could be that way. And could also be mergers or acquisition. But normally in Malaysia, we don't do that. We are not so big to go for that. But we can think about it. So normally it will be the family succession. In Malaysia, majority of the time, I see is more on the family succession. During the Majlis Pentauliahan for the new registered architects, you can see a lot of the younger generation taking over. You can see these people are going towards their professional exam and passing, and for them to take over their family businesses. Okay, so that's how the trend in Malaysia. So, steps to effective succession planning. Everybody who has got an ACP, think of this, the strategic preparation, establish a vision, what you want to do, your design, what your company is all about. Okay, and then identify also potential successes from when you already reached certain age. Please think about it. I think not just certain age, any age. As long as you know that you have to pass it on to somebody if anything happens. Just plan for it, okay? So, identify potential successes and develop a transition plan. It's always good to do it early. Then when the time comes and you have already passed on, suddenly. That happens many times also. Suddenly, passed on, and the family is left practically not knowing what to do, right? So develop a transition plan. Then we have, of course, on the valuation and financial planning, that part also have to think about. Communication strategy. I think all that communication strategy, valuation and financial planning should go under the transition plan as well. It should be all that. And execute and monitor, the last one, right? So this is the steps. Just I hope that everybody who has an ACP plan on this now. Okay, determining the new architect's responsibility. Very close, very slow. It's very, very detailed. You can take pictures, but it's still very detailed. Each one of our what do you call it, for the responsibility under the professional, statutory, as contractual, and the moral. For each stage, schematic design stage, the contract documentation stage, the contract implementation management, and final completion. So there's a lot of things. I think everybody knows that we practically have to cover so many things. So if a new architect taking over, this one determining the new architect taking over have to have ideas on how to settle all this. Yeah, the detailing. For example, I'm just giving an example, the schematic design. Is it taking over before the BP is approved, or what? Contract documentation, taking over after BP approved, before construction, things like that. So it's very detailed. You can see it. Yeah? You can refer to this. So anyway, the winning formula. Your signature is your liability. Your ACP is your legitimacy. Your discipline defines your success. Yeah? Because at the end of the day, it's you who have to be the one responsible. And you have to make sure that you are disciplined prudently. The one I mentioned just now, not just designing, not just understanding on designing and understanding the act, but as well as financial, as well as management itself, ACP itself. No? So that's why being disciplined defines your success. So anyway, thank you very much. Oh, actually, I've got 4 minutes to go, but never mind. So anyway, architecture builds spaces, succession builds legacy. Thank you.
Thank you. Thank you, Architect Sharina. We will now move into our panel discussion to stir this conversation. We are privileged to have our moderator, Architect Nazaruddin, CPD Committee, the co-chair of the CPD Committee. He will be moderating our panel discussion today. So together, we would like to invite our panelists on stage as well. So, Mr. Daniel, Mr. Chris, Architect Sharina, and I would like to invite Architect Hill to join us as well. Architect Nazaruddin, the floor is now yours.
Okay, thank you, Ms. MC. First of all, I would like to thank all attendees today. After listening to all the three speakers, Mr. Daniel, Chris, and Architect Sharina, I think we have privilege to have them present here, and we should take this time to get most of their experiences and knowledge in order to add on our knowledge and experience in running the architecture business. That's why we need to encourage PAM members to come and attend CPD programs. Apart from meeting our friends here, we can, most importantly, is to get knowledge, because we have been busy during Monday morning until Friday evening doing works. We didn't have time to study, we didn't have time to read. And this is the only platform that I think we should gather together and meet our friends and get more knowledge. Knowledge is very important in running business. And as architects, we should be getting the upper hand from the rest of the public. We are the architects. I would like to use the term used by architect Dr. Tan Lokman. He said architects are the guardian of this galaxy. So in Islamic term, we are the Khalifah. We manage this world. In order to manage this world, we need to have a proper knowledge. So only with knowledge, we can manage our projects proper. Okay? Okay, we have gone through 3 different but interrelated subjects. Mr. Daniels talks about the liability of architects. Even we pass away also, we cannot rest in peace, you know. And our Mr. Chris has enlightened us with his very lively presentation talking about strata. I think apart from strata, which is more complicated if you compare to landed schemes, with knowledge we can manage the scheme proper. Yeah, we need to advise the clients from the very beginning, because we are the first one in the project and the last one to go. So we need to know everything. And Architect Sharina enlightened us with what Lembaga Architects have in terms of the rules and regulation. So we need to follow, like what we heard in some film, you know, that actor said, Malaysia ada undang-undang, PM also go to jail, you know. Okay, now I want to open the floodgate. So when I open the floodgate, I expect a lot of questions from the audience. You grab this opportunity, forward your question, stand up, tell us your name and where you come from, and where you want to address your question to one of the panelists. Please, first question. Thanks.
Hello, good afternoon. I am Lim from KL. I have a few questions, very serious is impact to the architect's responsibility and also in related to the development's issue. The first thing is, as we know that one thing we always facing, very, very common. The developer or the contractor is very clever. They are very clever. Why? They have subsidiary company. Okay, registered under CIDB. Yes, everything have. And their subsidiary company sometimes have another subsidiary company. Anak kepada anak angkat lah. Okay, but they are very clever. Once they finish one project, during a DLP period when it's end or whatever, they shut down their company. They cuci buntut, they cabut. Okay, but we know that some of their main company, formerly known as what XXX company, they are same boss. They are same boss, same name after investigation. Okay, in this situation, as what we look for all generally, whatever happened to the Limitation Acts and architect responsibility from the Lembaga, okay, some report have been sent to architect, Lembaga Architect Malaysia lah. Okay, the negligence or everything's happened. So first is what is the cost of in our field can take action again to put some responsibility under the contractor and or the developer if they shut down their company and after certain period like under Limitation Acts, the buyer or whatever they found that certain thing non compliant, latent or patent defect, then everything go to the architect. When, let's say one case, if after carry on investigation, it found that if not an architect fault, it's a developer fault or the contractor, but they already shut down their company. So who is responsibility? Under Limitation Act, architect also bear something. Okay, their model, statutory requirement, model requirement, design negligence. Okay, and second thing is always, based on my experience, I caught and I scold them. Okay, especially during construction period. Okay, we have an inspector of work. We have RE at site or RA. So some of the development, especially the developer, they want us to use their own card of work. And we even though we have asking firm to provide another cut of work under our site, they refuse. Okay, what happened after this? When during construction, many things not closed, or RFWI not closed, or non-compliant done on site. When the architect inspect the site, they found non-compliant, we issue a non-compliant, and we didn't sign any payment until they make good. What happened? How to solve this problem? When the developer keeps pressing the architect firm, you must sign because the work done, but the clerk of work is under their site, not carrying out their duty. Is it in future, any enforcement may be put, responsibility also put under the clerk of work, wherever they are under which party? This is my concern.
Okay. Okay, it's a very long question, and actually it comprises many questions. But I just have to clarify, the Limitation Act only provides for the expiry date. So under the Act, it doesn't say what you're liable for. So it's only the expiry date. So in terms of duty, that's when you've got your UBBL, and then if you're designing a stratified development, you've got other provisions as well. So you need to have that distinction in your mind. So Limitation Act, it's only time limit to sue, expiry date. No duties there, right? So whether you win or not is a separate thing. It's just that the law says the claimant must sue, like just now, within 6 years. Whether he wins against you or not, it's a separate thing altogether. Okay, then the second point. Now, you mentioned, who will be liable and all. Now, for, let's say, development projects, if you're talking about the SPA, it's between the purchaser and the developer. The architect is not a party to the contract at all. Okay? So, and you've got cases, but I must say you have got cases where the purchasers have sued architects for breaches of the SPA. And that architect ultimately won. Okay, but then he had to incur legal costs. And I think it's, if I'm not right, it's quite a famous case, and the architect is one of our PAM members as well in Penang. So his experience is he won, but then he had to incur legal costs. That's why PI is so important, because ultimately, even if you've got documents to show that it's the developer's fault, it's the contractor's fault, but at what cost? So that's why you have to protect yourself as well, even more so when you've got such a situation where you've got just shell companies, where it's one company for every development project, and after that, I've experienced one case where upon completion, they will declare all the dividends to the parent company. So that company has got no more profits left, zero, and you can even check it from the SSM, financial statements. Okay, so there is no real hard and fast rule answer. It's just that you have to know yourself and know your rights and protect yourself. I mean, you cannot control the other factors, but you can control what you do. Okay, and in terms of the clerk of works and all, it's very important during the course of the project that you protect your scope. As in, if it's something within, that it's something within your scope, right? And other people may affect that particular scope. Then you have to write emails, you have to document it to say, okay, look, I have advised you A, but you have decided to proceed with B. And you save that email, convert to PDF, print a copy, put in your folder. Anything happens, reproduce it. Thank you very much. Not my fault. I've advised you, you proceeded with B anyway. So that's why documentation is so important. And always think, because they have got their own team of lawyers, they will probably say, hey, push lah. So you have to safeguard yourself, right? Any advice, if it's done verbally, record in writing, confirm in writing. WhatsApp, confirm in writing, email, right? It's not for reading, it's to cover backside, okay? Yeah, because these days, you get so many emails. It's not for reading. It's for record purposes in case shit hits the fan.
Okay, I like to mention about, you mentioned just now on defects. As I mentioned earlier, a lot of house buyers complain, not just house buyers, many parties particularly, but of course especially house buyers complaining to the board. Lots of cases. For IOs, for us lah, the board members, when we see these sort of cases, we know the responsibility to rectify the defects is the onus is to the developer. Because like mentioned in the SPA is between the developer and the house buyers, not with the architects. But being the principal submitting person, you have to monitor the rectification of the defects, find out when they're going to they're going to rectify the defects and whatnot. That's the part that you have to play the role. Okay? But normally, if you have done your part, you have done all the due respect of all your professional obligations on it, make sure that it's being rectified, this and that, the board will practically will treat it as no case. So don't worry. But you have to do your diligently settle the matter professionally. That's for the defects. For the clerk of works, okay, the term now we use in the UBBL, the latest amendments to the UBBL 2021, where all the G forms, there's also the IOW, Inspector of Works, have to sign off. Yeah. So that IOW is not the contractor's IOW, it's your IOW. So now we are going all out, promoting the IOWs must be registered with the board. We're promoting going all out because all respective ACPs should have your own IOW to manage and make sure that it's supposed to be according to your the construction is according to you, not the contractors. So at the end of the day, all G forms, I think it has already been amended in the UBBL. Only thing whether it's been gazetted or not in all the other states. The gazettement, but in federal, it's already there. I'm not sure which state have already gazetted that part. I'm not sure. Some have already. Okay, some have. Okay, but the term is basically that. So it's not that the act. It's not that they can scot free. The developers cannot just scot free and using their own IOW, right?
Okay, thank you, Mr. Daniel and Architect Sharina. Any other question, please?
Sorry, I have another one question also. Let's say just now is regarding the SNP issue regarding the buyer and the developer. As long as the architect carry out their duty, obligation to ensure that all compliance necessarily is complied to the requirement. What happened in the case that the architects have issued the certificate, fraud certificate, when the buyer found that the with an evidence, all the picture photographs attached, and even though the staircase roof insulation railing design not safe and not compliant to law, MS standard, and any related statutory requirement. But the certificate have been issued. And in this scenario, it is proof that the architect was negligent in carry out their duty. In this scenario, there's two different things can happen. The buyer either can sue the architect under the Civil Act. Okay, Civil Act is different case. Civil Act, they may include any injury or fatality happen if the negligence caused by the architect design. Okay, this is legal. So in this case, what happened to the developer part? If the developer, they say, I built this building based on architect layout, based on architect plan, and already inspected by architect, this is a proof that they issue the CTC, it's not my fault. Is it the developer still or the contractor still under the responsibility? Thank you.
Okay.
Just feeling boring in the middle, nobody asked me a question. Anyway, sorry, I'm seriously want to just address your issue. It's similar to a question that was thrown to me during the break also. Just wondering, just so that you know, in this case, when you talk about negligence, that word negligence is actually a third-party liability, right? When you say third-party liability means that it's actually the relationship is not direct. You understand? You're the certified body and whatnot, so you are not really the contractual party in relation to that. So there's also what we call, in the legal concept, we call it privity of contract in relation to that. A lot of time is about me suing the developer then sue the certified party in relation to that. Now, in the case that, because you mentioned that because developer can close shop, every time have a SPV for one project, they may not be there anymore, so what happened after that? Yes, being professional, we always have that problem. Not only you, architect, lawyer, summer, right? Anyone else for that matter. I just want to say to you is that for all intent and purposes, it got to do with how the trail is going, whether the buck stop where and whatnot, whether you discharge your public, your professional duty properly. For example, the issue about document it, email it, whatever, is to create a track, a record to show that you have done everything possible. Right? So I'm thinking to you is that we always take a very defensive position, right? And therefore, having a defensive position in our practice, plus the fact that we've got a PI, hopefully it all covered. So in that sense, that's what it is. But I'm just saying to you is that we cannot run away from our professional duty. If it's true that really we didn't comply with the act, it is not within the proper approval or whatever, and we certify it wrongly and whatnot, I'm sure there's certain liability on our side. So I just want you to understand that while, yes, we will say that the simple answer is to say that, yes, architect liable, because you certify a very simple answer, right? But in order to execute that liability, I would say that the road is not direct. I won't say it's not straight away, right? It has to go one and then jump to another one and then ultimately land on you. And that process, a lot of things can happen. So I just want you to understand that bit, my interpretation of what this is, although it's not really my topic. I can tell you, strata, as far as I'm concerned, the word architect, as far as I'm concerned, doesn't have a direct implication in all the strata title or strata management issue. However, it did pops up here and there. Correct? It pops up here and there doesn't mean anything. It means that you are the party governing certain factor in relation to that. So you are the gatekeeper. Like you said, Tan Lok Man said guardian of the galaxy, right? I would just say that you are just guardian of certain galaxy. One solar system saja. Sorry, not the god lah. The deities only lah. Alright? So I'm just saying that as much as you are important, you are not that important. I mean, so, sorry, no, with due respect, I must say to you, correct, you must understand, we have certain things we got, correct, all right, I just want you to understand you do have a liability professionally, you do got certain things, but not everything, okay, and like I said, there's privity of contract. Most of the time, the relationship between the home buyer or the property buyer to you is layered, cushion. You are a few layers after. Kueh lapis. Okay? Thank you.
Okay, Chris. You want to add? Okay. So, Chris, you can... you have we have a question at the back first. Okay. Yeah,
Hello. Hi, my name is Aisha. So I have this question regarding strata. Strata specifically. All right. So in this scenario whereby can you, in this one development, multi-story complex of mall and then towers, add on a link bridge after the strata title issued and put that particular link bridge under common property. This is one situation. Or during strata application, this is another scenario whereby in the middle of the application, the owner we wish to include a link bridge during the application themselves. That's my question.
Chris.
So I first question extend. Your question not link bridge where?
To another development.
Means outside of the strata. Correct? So
Yes.
how is it part of the strata? You know what I'm now asking now?
Yes, correct.
Correct? So like for example, link bridge to an MRT station outside. But it's still a link bridge, right?
Correct.
Crossing the highway to another side. So that link bridge, is it under the strata? You understand what I'm trying to ask now?
Yep. So that particular thing is come back to the approval drawing.
Yes.
Usually land surveyor to apply ciphers, they need the approval drawing to be submitted together during the application. So the calculation of that particular link bridge will tie back to the calculation of either it be put under the common properties later on or not. Because during, let's say in scenario first, you don't have any link bridge during the application of the strata.
No, again, I know what you're trying to tell me about ciphers and whatnot exactly.
Yes.
The link bridge is within the strata area or outside of strata area? That's my question.
It's attached.
Inside ke outside?
Inside. They attached to the building.
No. Attached means inside ke outside. You see, link bridge, half the bridge is inside, the other half outside.
Correct.
Yes or not?
Yes.
The half inside, consider yes lah. The full outside tak ada lah.
Okay.
So your question is?
Yeah, the one that inside, do we need to declare the area during the strata? Let's say you already strata out, that the area must be inside.
Can I tie back to your question about ciphers?
Yes, can.
Can ciphers stand for what?
Share unit. Share unit.
The ciphers stand for what? Sijil.
Share unit.
Formula unit share. Melayu.
Melayu, okay.
Not English. Alright. Sijil. Formula unit share. Yes or not?
Yes.
So basically, it's a certification of how you formulate your unit share, which means English, correct? How to formulate the share unit. So to me, as far as ciphers is concerned, you don't have any allocation for that link bridge, unless the link bridge is owned as a parcel. You know what I'm trying to say, not? Alright. Kalau dia common, dia memang tak ada impact dengan ciphers pun. Correct, if it's common. You understand what I'm trying to say now?
Okay. I'm trying to digest this.
Correct.
Okay.
If it is a common property, there will not be share unit allocated. Melainkan that link bridge is privately owned.
It's privately owned.
Means you do it as a parcel.
I see.
Or an accessory parcel to a parcel. Let's say
yep.
It is linked to a main parcel that is a shopping retail lot. And this shopping retail lot offer the link to the another development or outside the development area. You understand not? And that is being allocated to that retail lot, the retail parcel, as an accessory parcel. You understand not?
Yeah.
Then you talk about ciphers. Otherwise, there's no ciphers here. So I'm just trying to clarify that question. Yeah.
So then if it's a common property, then it will not be a problem whether it's during the application or after the strata title is already out.
Sure.
I see. All right. Thank you.
Okay.
I just want to try to understand. I think basically she's trying to ask when the building is completed, now that the owner want to renovate and add a link bridge, how will it affect the strata title as a whole?
Oh, okay. That's a different question, right? Is it that question? Okay, so if that is a scenario that's different, for example, that is where is, remember I did in my presentation, I talked about post-CCC. So now you're trying to have something beyond your strata title issued. You understand what I'm trying to say? Strata title issued. You're trying to build something beyond your strata title, yes or not? So you ask me, that part of it is not covered under your strata title. Is that right? You know what I'm trying to say, no? To me, it tak jalan lah. Not workable. If you want to finance, there's even a problem. Even you got extra area of saying, hey, it's not reflecting your title. Even if I give a valuation, that part of it doesn't have a value.
So can I say that that structure could be legal under the building department, but strata fights that there's no value to strata.
And plus, from the financing point of view, instead of adding value, you are now impacting the value. Could be lower, because it's not as per your title. The bank will look at it. Ini tak sama. Correct? So it's like, you know your car? I use back the car, very easy one. You got to modify your car. Sampai JPJ didn't approve, or even approve. It doesn't look like the car that is being being a higher purchase or charge to the bank. You understand that? Then you are now destroying the security. In fact, the bank will now go after you. Now, because later, if I need to foreclose the property, I would have a problem. Faham tak? It's like your renovation for your house got approved, not approved. Then later, if you foreclose, what's the problem? It's the same thing lah.
Hello. Lim, I refer back to a question just now.
Yes.
Let's say the link bridge is within the boundary.
Yep.
And the development is completed.
Yes.
Right. And the owner of the building would like to gain this link bridge by means of submission and approval. Can he later legalize it or formalize it by subsequent application to the authority to issue a new strata?
So I said post-strata title issues.
Post-strata title issues.
Post-strata title issues, you want to add a structure into it, yes or not? Correct? A floor area into this area. So now the question is this. The question is this. Is to be added as a common property.
Common.
Correct? Common, remember they said common, everything that is not specifically privately owned under stratified title as a parcel would be common. So theoretically, that legal definition fit still. Then the next question is, who's the applicant?
The JMB.
The MC.
MC.
By the way, let me just highlight one very important thing since you mentioned JMB. Sorry, I just thought it's very important for you to clarify. JMB cannot. For a start, just hear me out here. JMB cannot apply. Why? JMB is not the owner. The owner is only the MC. Legally, I have to tell you the legal owner at that time is only the MC. During JMB, who's the owner? Anyone know? Developer. It's still the developer because why is it JMB? Is because the strata title not issued ma. Agreed? So if you go and do a land search, who is the owner of the common property? Which means the master is still the developer name or whoever the original land proprietor lah. Betul? So legally there's a concept. So you mentioned JMB, I just want to correct that in a very sense. JMB can never apply. JMB in the context of Strata Management Act and Strata Title Act is just a management entity. Nothing more, nothing less. Understand? So it's either the developer, the original land proprietor, if there's a JV involved or whatever, right, prior to the strata title issuance, or the MC. It has to be like that. I give you another further situation. Let's say this is a limited common property whereby sub-MC have been formed, correct? And then you now have additional structure within the LCP area. How about that? Complicated, right? Correct? Applicant, MC. Because sub-MC is the same as JMB. Management entity sahaja. Sub-MC don't own anything. Still the MC. So therefore, AGM-wise, 2 times. Sub-MC 1 kali, MC 1 kali, baru boleh apply. You understand the complication? So I just want to highlight to you because these are the nitty-gritty you must know. That's why because you are fellow professional, I expect you to use the right term. The moment you say JMB, I know your understanding is not complete. That's why I just want to help you to clarify.
Thank you.
Thank you.
Yeah, okay, understood. So thanks, Daniel. I think we understand that the powerful is at last.
Please. You have a question? Sorry.
Hope not last.
Last.
Okay, I have 2 questions. The first is about PCWD. It is under DOSH CWDM 2024. It seems like LAM have issued a circular, clarifying their stand on this PCWD. But recently I attended international developer, which insists that we take the role, and they even further explain that they're going to pass it to the design build contractor later on, and they want to pass this PCWD responsibility to another party. So it's like we are professional like a ball, being kicked around, and hold all this responsibility. So what is the, or who else can take that responsibility lah? That's my first question. Second question is about moving ahead for the future. There's a trend now is about modular housing. So a house comes just like a container. And nowadays they have the technology to stack the house lah, higher, come to back to strata. And it is it's complete, and they go link with corridor and so on lah. In fact, I'm building one now, getting the supply from China lah. So how does this, I just want to talk about liability of us as a professional. You see, this is a product, you know. They built the whole thing. So as a professional, we don't know what they use in detail, or it's not for us to go check and everything, you know. And how far does the liability as a professional we have to take? I think this later relate to the PI. They also want to know, you know, if you use the modular housing. I think they sell a lot now out there, modular housing. How does the architect liability come into the picture? Thank you.
Okay, you can let Chris to answer that, please. Daniel. Yeah, Daniel.
Yeah, at least for CDM.
On the legality.
Yeah. Okay. Yeah, I think for CDM 2024, because it's something very new, and I think it's safe to say that we've got very conflicting positions. I think on one hand, DOSH really wants the architect to assume that portion of liability, and that's quite consistent with the developers as well. As far as they are concerned, they just want to push everything to the architect, and if they can, at no additional fee as well, and that's not acceptable. But on the other hand, for architects, I understand the position is that, well, that cannot be the case, because for certain phases of the project, you are not actually that actively involved, not as involved as the contractor. Okay, especially when they're on site, sometimes they would even bypass you. They make certain decisions and you don't know what are the daily decisions that they make on site. Right, for you, it's just occasional advice here and there, and then at the end, PSP. So I think PAM is working on something, because now even the regulations, there are no guidelines. The guidelines, I think the latest one is in 2017, and that's prior to the 2024 regulations. So you don't have the latest set of guidelines, but PAM, I think, is driving it. I think the idea is that we would like to align the role and responsibility of the PCWD with your existing workflow as an architect. So if it's pre-construction phase, then fair enough, because you already have got engagements with the consultants and all, and it's already an internal discussion that you have anyway, you know, because you have to comply with the UBBL anyway. It's just that now it has to be a bit more formal. There has to be some record, okay, in your capacity as the PCWD, because the other consultants already are construction work designers. So you've got CWDs, and then you've got someone heading and spearheading that progress, right? So now during the pre-construction phase, it's just that the architect must really record, okay, here's the checklist, here are the things we have to look out for, right? And then you have to develop the safety and health file. But unfortunately, we don't know what should be in the safety and health file as well. So it's really a case where everyone is, I think, equally blind. And I think for DOSH as well, sometimes when they come out with regulations, I don't know particularly if they understand what it is that the architects do on a daily basis, you know, from start to finish, because there seems to be a gap there as well. So PAM is trying to at least align the regulations with what the architects are already doing on a daily basis. And the idea is to have an exit whereby prior to construction, that's where you say, okay, that's where I draw the line. And during construction, perhaps the PCWC, the principal, the PC...
Daniel, maybe I can just add on that, because what Daniel has mentioned is basically some idea, something that is actually a work in progress.
Yeah.
But I just want to sum it up because there is not so much into what we are talking, but maybe just a bit touch on liability. So this, I think right now, I would expect it to actually, since you asked about CDM, right? I thought we will survive, we will talk about it. CDM been a very hot topic last year. So I think PPC and the PAM PPC, we've been taking up very proactively with JKKP. There's several engagement that we had, but unfortunately it's not very fruitful. So what happened this term or this year onwards, there's this, we have a new, actually it's an assisting working group, safety and health, and that is actually led by David Teo, and Daniel is also part of the team. So the intention right now is, instead of we waiting for the GP teaching us what to do, because basically CDM, right, there's a regulation. There's a very brief GP guidelines on what to basically interpret the regulation itself. What I see is quite brief. So there's no template, there's no guideline on how to use, and everything is on very high level. So instead of waiting JKKP to give us a standard, right now you know that in the market there is a developer standard, there is some private developer, they have their own things. So JKKP maybe have their own template also. So what we are doing right now is we are setting our own guidelines, which will include the GP, the guideline on how to use. There is some templates on how do you form some of the files or documents that require in there. Of course, I think very, very important is the appointment. When do you enter, when do you exit, like what Daniel said, but particularly within the scope of our CCC scope especially. So all these are work in progress. I think we are targeting to get it out maybe in 2 months' time. By then, I think this will be another critical thing that going on within PAM. So I think that will be a good update for now. Thanks for asking that. Thank you.
Sorry, RIBA has done 2 books series.
That is also part of their references. Yeah.
So they even do simplified tabulation of the metrics of responsibility. Yeah. And even them already try to discard the portion where when you start construction, because safety health should be under contractor.
Yeah, maybe
exactly like what you said.
You can take note on that.
So maybe later I can share my findings as well.
Thank you.
Okay, just to add on that, what Hugh mentioned on PAM, because PAM and LAM both are actually working on this as well. When we go and have a meeting with DOSH, we go together and again agree. When it comes to guidelines, DOSH, even though I requested them to come up with a guideline, they also have no idea. So thank goodness, thank you, PAM is doing something on it, because we expect if it comes from them, they may even include things that is beyond us. Yeah. So may as well we set it, and we have repeatedly we tell DOSH that we have to cover basically pre-construction only, not during the construction. But I think they don't understand. Many times we tell them, but they still don't understand. But never mind, we still proceed on this. But it's still in progress, as mentioned by Hugh.
Okay, thank you, Architect Shazna. Chris, you want to comment on the modular, please? Modular thing? In fact, the strata? What? Modular housing.
What's the modular thing?
You see,
is it the high-rise or landed? Modular.
This modular housing
landed
is
or high-rise?
Prefabricated. Yeah, it used to be landed.
Okay. Now?
But now with that technology, there's the highest modular housing is in Cordon, south of London. They do modular proposing 62-story high.
Oh. No,
so
now what you are proposing?
So in Malaysia, like what I'm doing now is 5-story.
Okay.
So it's Strata Titles is going to come in the picture, and you know, and I think whatever you understand.
Your question is. Sorry, I understand modular. Yes, you're gonna apply for a strata building. You're gonna use modular construction method. Agreed. So your question is?
You see, under this modular, it's not a permanent structure.
Okay.
So it goes under certain. It's like leasehold for mine, currently I'm doing is 25 years.
Sure.
So after 25 years, you know, and within the 25 years, what are the strata implication of the common area or,
Okay,
or the ownership of the
I understand
house?
what you're trying to say. Let me rephrase your question, can I? Just so that for our better understanding. So you are saying that it's a temporary structure, whatever, right? So basically, maybe as a result of it, the strata title is also limited in terms of tenure. So let's say the strata title tenure is 25-year leasehold lah. I'm just playing along. 25-year leasehold, right? So what happened after 25-year leasehold, yes or not? So as far as the strata scheme, if it's a strata scheme, let's say I'm just playing along your question and say it's more than 25 years and whatnot, right? It's the same. Let me ask you a question. Do you have strata project that's 99-year leasehold at the moment? Got right? Leasehold property, yes or not? Question is, so at the end of the thing, then there's a time you can actually apply for the extension of the tenure, yes or not? Integrity of the building is a separate issue. So I just want to let you know, integrity of the building is a separate issue, but stratified scheme to extend beyond it. So the next question is, how do you then apply for the strata extension? The tenure extension for a strata property. So the question is, 100% need to go, can I have like, for example, out of the 100 stratified title unit, only 50 of them want to extend, the other 50 don't want to extend, what happened to the rest? Correct? So let me ask you a very simple question. Logic, using same logic also. At the end of a leasehold tenure of that building, let's say it's 99 years, now 99 years already lah. Correct? So the entire building will go back to the authority, yes or not? Correct. Simple? Correct? So let's say I offer for extension, but only 50% of it want to extend, the other 50 don't want, right? Let's say lah. So whoever pay for the premium for the extension will get the relevant period of extension. The rest of the unit owned by the authority. Yes or not? You know, we're just going back to the same concept and let it run. So I don't think it got anything to do with your modular, for example, but it got to do with the tenure of the title. That's more important. You know what I'm trying to say, not? But it's the same today. I'm saying to you is the 99-year leasehold scheme that we have is also common, ma. Correct? And then you could have a commercial strata or industrial strata that's even lot lesser in terms of the leasehold period. What happened to the structure?
We got urban renewal, Chris.
Correct, I know. But urban renewal at this moment is premature. Urban renewal means it's like 100%. That one got nothing to do with tenure because for as long as we've got 100%, everything can do. Okay. Correct? Yeah.
Okay. I would like to thank you, audience and speakers for coming for today's CPD. I'm sorry I cannot get any more questions because of the time, but they have another session in the afternoon. You know, if you are free, you can attend. On behalf of PAM, I would like to thank all the audience, and I would like to thank our speakers today, Mr. Daniel Tan, Mr. Chris Tan, and Architect Sharida, and also our chairman, Architect Hugh. Thank you for coming. Please help me to give a round of applause. Thank you. Thank you, and see you again.